States Court of Appeals for the First Circuit is now in session. All persons having any business before this honorable court may give their attendance and they shall be heard. God save the United States of America and this honorable court. Court is in session. Today's cases will be called as previously announced and times will be as allotted to counsel. The first case today is United States versus Dennis Ayala, appeal number 191936. Attorney Lee, please introduce yourself on the record.
Good morning, Your Honors. My name is Jane Lee, and I represent the defendant, Dennis Ayala.
Good morning, Ms. Lee. Please feel free to proceed with your argument.
Your Honors, in the present case, the district court committed clear error in determining drug quantity in this case and the resulting guideline. It's the government's burden to prove drug quantity by a preponderance of the evidence. It's the court's duty to find drug quantity by a preponderance of the evidence. In this case, probation converted 3 amounts of cash to drug quantity. They converted $5,720 found in a safe to drug quantity. They converted a $5,000 with bank withdrawal and a $3,300 bank withdrawal to drug quantity. Now, the last 2 bank withdrawals were converted to drug quantity because they were withdrawn on April 24th, April 26th, which was 2 days before a drug transaction in this case on April 26th. In the present case, the court could not find by a preponderance that both of these cash withdrawals were used to buy money on were used to buy drugs on April 26th. And the court couldn't find that by a preponderance because the defendant, both the defendant and the government, contested the drug quantity in this case. And defendant didn't just contest the drug quantity, but he submitted evidence that the $5,000 withdrawal on April 24th, 2 days before the drug deal, was to pay his bail in the state case. He submitted evidence that his bail was paid on April 24th, the date of the withdrawal, that the amount of his bail was $5,000, the amount of the withdrawal in this case, and that he repaid that bail to his stepdaughter who paid his bail. He submitted receipts from the state case. So that amount cannot be found by a preponderance in this case to be used to purchase drugs on the 26th. Moreoverly, in addition, there was another drug deal in this case, and it was on May 22nd, and the amount of that drug deal was $4,500. Now, the court attributed both withdrawals, the $3,300 and the $5,000, to the April 26th. I'm sorry, probation, not the court. Probation attributed both withdrawals to the April 26th drug deal. But that's $8,300, and there's no evidence in this record that defendants' drug deals were that amount. The only other drug deal in the record was for $4,500. So that adds to the argument that there's no preponderance here. That $5,000 was for bail, and defendant paid that $5,000 for bail. So you can't attribute that you can't convert that $5,000 to drug quantity. And so the court erred in finding that was.
Just clarify one thing. Was there any indication in the district court's ruling that the $5,000 was itself drug proceeds as opposed to money to use to purchase drugs?
Well, yeah, Your Honor, that's very interesting because probation said that these monies were used to purchase drugs on April 26th, but the court never makes any kind of finding except this. The court finds that all the defendant's money, all the defendant's assets, they're all drug money. It's all drug money. All his assets are drug money.
Right,
that's the court.
I guess you could answer my question, which is one possibility is that the $5,000 were used to facilitate what would be a subsequent purchase of drugs on the 26th, and you're saying that's implausible because the evidence is the $5,000 was used to pay bail. But is it possible to find on this record that even if the $5,000 was used to pay the bail, the $5,000 came from a sale of drugs that was prior, so that it was itself drug proceeds? Because I thought the district court may have been suggesting as much. Could you just address that point?
I don't think the district court suggests that. The district court mentions the $5,000 once, and he says that $5,000 was withdrawn on the day of the April 26th drug deal. That's all he says about it. And that's wrong, actually. So he doesn't even say that. And there isn't any evidence in the record to say, oh, this is the profit from the drug deal that went before. There's no evidence in the record of that.
What do you, Ms. Lee, what do you say? The court did express skepticism that the defendant would have, quote, such a substantial amount on hand for someone who's been on disability, and then said, I don't see any way that this individual could have accumulated those sums of money with no employment and a disability benefit. It sounds like he was saying what Judge Barron was suggesting, that the judge was referring not necessarily to the intended use of the money, but rather to the source of the money in the first instance.
I think he was saying that. I mean, I think he says a lot more. I think he globally says that all of defendants' money is drug money, including these. And I don't think that's a valid.
5 minutes remaining.
That's not a finding of fact. That's not an inference based on.
No, it's not a finding of fact. The question is, it's an inference from the evidence before the court. And what you've got to persuade us of is that that inference is not a reasonable inference under all the circumstances.
Well, it's not a reasonable inference under the circumstances, but I would say right off, it's not even an inference. It's an assumption, because you don't have any evidence of where that money comes from. But it's not a reasonable inference because once the court made this statement, then defendant went on to defend himself by submitting evidence that he had a $250,000 insurance proceeds that he banked in 2013. So he had other money. He also went on to say that, the judge talked about all his assets. His house was in trust. His house, he didn't purchase his house. He had, he talks about all his assets, he's talking about 2 used snowmobiles, motorcycle, and a truck that were purchased a long time ago. And those kind of assumptions, cannot be used to support specific conversion of a specific amounts to drug quantity. We're talking about relevant conduct here. It's got to be related to the course of conduct, the conspiracy in this case. You can't just go back this way and say, oh, everything's drugs. You got to go this way and say he used it to buy these drugs in this conspiracy with these people on this date.
What's your authority for that? Because I don't think that's correct. I think if the court makes a supportable finding that the defendant's cash, and he had a considerable amount of cash, including the cash in the safe, is drug money, that would be enough to justify the enhancement.
Well, Your Honor, under that theory, that he doesn't have to connect it to the course of conduct in this case or this conspiracy, every dollar he has in the bank can be drug money. Every asset he has can be drug money under that theory. And I don't think this court wants to say that, because way back in 1989, this court said, we're not even going to address the speculative and remote possibility that courts will start converting houses and cars into drug money, into drugs quantity. I mean, we never done that. We don't do that because it's got to pertain to the course of conduct in this case to be relevant conduct.
You might want to address the alternative argument that even if this was error, even if the facts weren't enough to support the inference, the court independently seemed to say that it would have set the sentence at the same amount anyhow.
Yes, the court did say that. The court has a single sentence where the court says, under either guideline, under 30 or 28, I would have given him 108 months. But that's a post-sentencing statement. And that statement follows 2 hearings, a hearing and a continued hearing, where the defendant presented evidence, the court accepted it. Molina Martinez says that when you use the wrong guideline range, it's prejudicial if the parties anchor their sentencing arguments in the application of a certain guideline, and that guideline is the focal point of the hearing. And that's exactly what happened here. And it's the government's burden to prove that this error was harmless, and they can't prove that based on a single post-sentencing statement. I mean, if that was the case, he didn't have to decide drug quantity. He could have said, yes, I'll go with the plea agreement. The plea agreement was for a base offense level of 28, and then sentence him to 108. But this sentence, this post-sentencing sentence just insulates his findings from appellate review. And that's not what the court intended, the Supreme Court intended.
Is it a bit more than a single sentence? He also said, I have carefully considered the advisory guideline range. I give the guidelines no controlling weight. He then went into the 3553A factors. And then at the end of that, he uttered the sentence that you referred to.
Well, I think that I give the guidelines no controlling. I mean, that's for any sentencing. That's how I read it. He would say that for any sentencing. Yes, you consider 355 factors. You do this. This is how you proceed with sentencing, and then you set the guidelines, which he did.
Can I just ask you a practical question? If a district judge says, I'd give him the same sentence, what is the point of remanding to that district court when he's told us what he's going to do, even if we conclude that it's a different range?
I don't think there is any point in remanding to that judge. I think you have to remand it to a different judge.
Well, what's your authority for that last proposition, that when there's a guideline error, that we have to give it to a different judge? We don't ordinarily give it to a different judge.
You don't ordinarily give it to a different judge, but in this case, I think that given this case and the way it plays out, that this judge will be unable to be neutral and fair.
Thank you, Ms. Lee. Are there any more questions?
No.
Thank you.
Thank you.
Attorney Lee, you can mute your device at this time. And Attorney Falk, if you could unmute your device. And introduce yourself to the record, please.
Thank you. Good morning, Your Honors. I'm Noah Falk, and I represent the United States of America in this matter. So I'll start where the court left off in the last argument. Although, we firmly believe that the court was correct in its guideline calculation. The reality is that any error that may have occurred in the guideline calculation would be harmless because, as the court pointed out, the district court affirmatively stated that its sentence was untethered from the guidelines. The court went through and identified the various factors that it was relying upon in imposing its 108-month sentence. The court stated that the appellant was a long-term drug dealer starting at the age of 29. He was a career dealer. He continued to be involved in dealing drugs through the present at that time. He was 51 years old. He continued to deal drugs even after his arrest in the instant case. He had no intention of obeying the law, no respect for the law. And the only way in the district court's view to prevent him from engaging in further drug trafficking was to impose a lengthy sentence. The court recited his drug level or his offense level findings, which was a level 30, and noted that the guideline range would be 108 to 135 months in that case. He also said that the guideline range that the appellant argued for, level 28, which would have yielded an 87 to 108 months if he had found that range. I'm sorry. In short, he concluded with, in my view, the 108 months is appropriate under either set of circumstances, and that's in the record docket 223 at page 9. Now, the appellant attacks the court's sincerity. I mean, he essentially says that the reason that the court should disregard the district court statement that he would have imposed this sentence independent of the guidelines calculation is that a lot of the sentencing proceeding was devoted to determining the drug calculation. Well, the district court has a duty to find the correct guidelines range, and that's what the court did. Now, If the court had failed to do so, that would have been procedural error, as the court recognized in U.S. versus Tavares. But so the court took its obligation seriously. It afforded due process to the appellant. It found the guidelines range, and then it imposed a sentence that was untethered from that range based on its review of the record. So so even if the court was wrong in its assessment of the guidelines range, which we think that it was not, that error didn't result in a different sentence. And so it's a harmless error. Apart from that, the court correctly calculated the guidelines range. There was plenty. Well, look. Let me just go back to the correct analytical framework here that governs this case. I think it was announced by this court in U.S. versus Sear. That's at 337 F. 3rd 96. It's a case that is not cited by the appellant. That case indicates that the court can rely on the PSR at sentencing, and the defendant can challenge any assertions in the PSR with evidence or proffers. And if as a result of the defendant's challenges, there arises a genuine and material factual dispute, the court is then obliged to resolve that on the record. But if the defendant's objections are merely rhetorical and unsupported by countervailing proof, the court may continue to rely on the facts in the PSR, and that's exactly what happened here. Although,
take counsel, take the $5,000 found in the safe.
Judge Cata, I'm not sure Judge Selya is still.
Yeah, I'm here.
Oh, you are? Okay.
I'm just being unaccustomedly quiet.
Okay, your video went
Oh,
off. But,
okay.
Yeah. Sorry about that, Judge Cata.
There he is.
So take the $5,000 in the safe. What in the record do you point us to that would suggest that $5,000 came from drug dealing instead of from the $250,000 he had previously received? I think you have to admit it could be either. So what makes the drug dealing more probable?
well, Your Honor, I think the best piece of evidence that
5 minutes remaining.
Thank you. That this $5,000 was the result of drug transactions and not money that came from the $250,000 windfall is that the appellant admitted that the $250,000 had been spent by the present day, and that's in the record in the continuation of the sentencing proceeding at pages 3 and 4 of that proceeding. It's docket number 223, pages 3 and 4. The court asks, I've reviewed the bank records and I'm unclear where that money is at present. And the court is referring to the $250,000 windfall that the appellant received in 2013. The defense attorney, Mr. Mackey, replies, well, that money was used over a period of time, Your Honor. And then a little later on, he says, in terms of where that money has gone over the years, that would be contained in the literally thousands of other pages that the defendant declined to provide to the court. So the appellant is admitting that the legitimate source of income that he's trying to prove was already spent by the time that the instant conduct occurred. So then what you have left.
Can I follow up on that? I thought you just said that the judge asked, where's the money at present?
Right. That's correct, Your Honor.
But the $5,000 was supposedly spent on the bill, not at present, but beforehand. So everything you just said about the money over time was spent is consistent with the idea that the $5,000 could have been part of that prior spending, right?
No, Your Honor, I don't believe that that's what the appellant was meaning to say. This colloquy relates to the $250,000 windfall that the defendant received in 2013. And what I believe the court was trying to determine with respect to the $5,000 is could this windfall be a part of the $5,000 supposed bail payment that was made, in April of 2018? And I think what Mr. Mackey is saying here is that it couldn't have been because the $250,000 had been spent prior to the cash at issue. I mean, really what the court wanted to know and why it left it continued the proceeding in order to permit the appellant to provide additional documentation and proof about this windfall is, can we trace the windfall from the time that it was paid in 2013 down to the present in order to refute the court's assumption that all the money that the appellant had on hand was drug money. And what the appellant essentially said here was, we're providing you with, documents that show that we received the windfall, but we aren't able to provide you with documents sufficient to trace the money to today because that money has been spent. And so the $5,000, whether or not it went to pay bail, it was drug proceeds. The appellant was a career dealer. He had no source of legitimate income apart from a modest Social Security allowance. And by the time the instant conduct occurred, the windfall was gone, even according to the appellant. And so I think the court was right to conclude that the majority.
One thing that's just a little to me is, if the district court was basing the conclusion that the $5,000 was convertible as drug money, why is the district court, based on an idea that that $5,000 was proceeds of prior drug sales, why is the district court so concerned about connecting the timing of that withdrawal to the timing of the future drug purchase? To me, that suggests the district court was under the impression it was drug money, at least in part, because it was going to be used to buy the drugs.
Well, Your Honor, I don't believe that it's an either or question. I believe it's a both and question.
Yeah, but suppose the part of, if half of that is wrong and unsupportable, what do we then do?
Well, I'm sorry, Your Honor, which half do you think is wrong?
Well, the half that seems harder to support is the idea that it was withdrawn to purchase drugs, given that there's pretty good evidence that there was a $5,000 payment made around that exact same time to pay the bail in the state case. So it seems at least 50-50 whether that $5,000 was being withdrawn for that purpose or for the future drug sale. And so if the district court was under the impression that it was drug money that could be converted to drug quantity because of a future purchase, and the record doesn't support that, I'm not quite sure what we do if the district court also sort of throws in this idea that it was all proceeds. In other words, the district court seems to have both theories going with respect to this one payment. Half of that theory seems to me hard to support on a preponderant notion.
Well, Your Honor, respectfully, I think that the only evidence that the appellant provided that particular $5,000.
That's time.
May I just finish answering the question?
You can finish your answer, yes, please.
Thank you, Your Honor. The only, sorry, I've lost my train of thought. The only evidence that the appellant provided that particular $5,000 related to the bail payment was a receipt that indicated that bail was paid by a third party on that day, and his own self-serving statements that $5,000 withdrawal went to pay bail. The evidence that the appellant presented didn't show that $5,000 was paid by the appellant. It was paid by a third party. So I think even if this court finds that the district court was incorrect that $5,000 was drug proceeds, there's still, the court could still find by a preponderance of the evidence that the $5,000 was connected to purchasing drugs. And I think that the operative thing for the court to keep in mind here is the clear error standard, right? When there's when there's more than one plausible view of the circumstances, the sentencing court's choice among supportable alternatives cannot be clearly erroneous. And I think that's where we end up.
Thank you, Mr. Falk. Judge Selya, Judge Barron, did you have any more questions?
No,
Thank you, counsel.
Thank you, Your Honor.
That concludes argument in this case. Attorney.
Please proceed.
Yes, Judge. The next case is number 201340, United States versus Pablo L. Rivera. Attorney Lockhart, please introduce yourself on the record.
Yes, Donald Lockhart for the government, and may it please the court, may I reserve 2 minutes for rebuttal?
Yes, you may, Mr. Lockhart.
Thank you. May I proceed?
Please.
So this is really a textbook case where a trooper should remove a car from the side of the road by having it towed, and then prior to the towing should conduct an inventory search. The district court erred in ruling otherwise and in suppressing all the evidence that was derived from the inventory search, including the heroin, the loaded firearm, the drug accoutrement, and Mr. Rivera's remark about the salt.
Mr. Lockhart, let me just ask you one question. The district court also suppressed the defendant's statement at the scene, his answer to a question of the troopers. I don't believe you challenged that that ruling in your appeal.
No, we do challenge it. That's the salt remark that I was just referring to.
All right.
Yes, just to clarify before turning to the main part of the argument, the district court's view was that all evidence that stemmed in any fashion from the inventory search, including the salt statement of the defendant, needed to be suppressed. And so we challenge the entire gamut of the suppression ruling. Unless the court has a different preference, I'll start with the impoundment first and then go to the inventory search second. As far as the impoundment goes, you may recall that Mr. Rivera conceded in the district court, and again now apparently on appeal, that the impoundment was lawful because after the police pulled him over the side of Route 84, it was quickly discovered that he lacked a license and nobody else was present in the car to drive it from the scene. So a written state police order directly on point authorized the towing of the vehicle from the side of the highway, and that's exactly what the trooper did. Now, the district court didn't specifically fault the impoundment decision, but it did say, or suggest anyway, that there was no impoundment at all because the defendant's car, according to the district court, was never in police custody. Now, we addressed that point in our brief, but suffice it to say that the Supreme Court's decision in Katie says that when an officer is having a car towed at the behest of the police, at the direction of the police, that car is in police custody. The police are exercising a form of custody or control over the car in that circumstance. And the mere fact that the trooper initially offered to Mr. Rivera that he could ride with the tow truck once it arrived wouldn't change that calculus at all, because even if Rivera had ridden with the tow truck, the fact of the matter is that car would have remained in police custody. It would have been towed at the direction of the police. The court has no questions about the impoundment phase. I'll switch gears and talk about the inventory search phase of what happened. Again,
Mr. Lockhart, could you clarify two things? You say Route 84. Are we talking about Interstate 84 in Massachusetts?
correct, Interstate 84 in Sturbridge.
And then is there any evidence in the record as to where the tow truck was taking the vehicle?
The only evidence in the record concerning the tow company is at page 11 of the addendum to our brief, which is a single-page document. It's the inventory search form that the trooper later filled out.
4 minutes remaining.
And it refers to the name of the tow truck company, but I don't believe it refers to the location of the tow truck company. From memory, it's something like Interstate Towing. But I don't believe the suppression hearing record reflects the distance between the point of the stop and where the tow truck company was located.
Can I ask, before you go on to the next phase of your argument, I just want to make sure I understand something about the terminology you're using. When you use the word impound, what is the legal significance of that word that you're keying it to? Is that the same as seized, or do you mean it differently than seized?
So, no, I'm not referring to it as a seizure. It's more a term of art that is really shorthand for a decision to remove a car from the side of the highway by having it towed. I'm calling that
the reason why I just asked that is suppose the trooper here had said, "Oh, you don't have your license." "No, I don't have my license." "You don't have registration." "No registration." "Okay." And then the driver says, "But I'm a AAA member. I'll call AAA. They'll come. They can tow it for me." And the trooper says, "Yes, that's fine." At that point, is it useful to call it an impoundment? Or is it significant that what happened here, for purposes of using that word, that the trooper said, "We'll get the car towed"?
Right, it's the latter. In other words, even in the scenario that you just described, where the officer tells the defendant, "We need to tow your car from the scene," and the defendant proffers his own tow truck service, AAA or whatever, it is still the case in that scenario that the car is being taken from the roadside at the direction of the police.
Well, that seems surprising. I mean, suppose he had a passenger with him and he said, "I know I can't drive, you're right, you got me, but I'll have my friend drive it home." I don't think we'd say the police took the car into custody and impounded it in that situation. And how's it different if he says, "There's a tow truck company, I'm AAA, they're right around the corner, they'll come get it and take it off the road"? He wasn't being arrested, he was free to go.
Right. So the distinction, Your Honor, is actually embedded right in the state police tow policy.
That's what concerned me, is that I think the word impound is important to you because you're keying it to the state policy. But from a Fourth Amendment perspective, the state policy can't be determinative of how reasonable it is to do an inventory search. In other words, if you're trying to leverage the idea of it's an impoundment under the state policy, therefore the inventory search is permissible whenever it's an impoundment under the state policy, that just skips over the question of whether, from a Fourth Amendment perspective, there is a community caretaking reason to allow the inventory search. I guess I'm not quite following why there would be in either the scenario where there's a passenger or where he's getting his own tower. Here we have neither, because the trooper was the one calling the tow truck, so that does seem to me quite different. But I'm a little concerned about the suggestion that there's no difference in those scenarios because they're all impoundments.
Well, let me address your question, and I believe Judge Kayada's question, which I haven't quite gotten to, which is the scenario of the person in the car who is able to drive the car from the side of the highway. Of course, that's a completely different situation where there's no need to tow at all, right? There's no need because, as the state policy reflects, and as just the, as a matter of reasonable community caretaking standards, we have a situation there where somebody is present in the car and can actually drive it away. So there's no need for the trooper to intervene and call it a tow truck. So that seems to me to be a completely different scenario. There are many issues I haven't gotten to. I've reserved 2 minutes for rebuttal, and I'm happy to rest at this point.
Well, if you wish to address Judge Barron's question, or if you feel you've already done that, that's fine.
I thought he was posing essentially the same question that you were posing, Judge Kayada, but
you addressed the half. You addressed the half of it with the passenger. I guess the other case that's slightly different than this case is it's not a passenger, it's a friend with a tow truck, and the friend's going to come with the tow truck. You seem to treat all towing, regardless of whether the towing is at the behest of the driver or at the behest of the trooper, as the same, and I'm not following why one would do that.
Well, in that scenario, it's still at the behest of the police. It's just the defendant is expressing his own preference for a tow truck company to take the car away. It's still primarily a police decision that this car cannot remain at the side of the highway.
But now you've gone from custody to decision. That decision would be the same with the passenger.
I don't follow you. I'm sorry.
Sure. If he had a friend who could drive, the police would be making a decision. The car can't stay on the side of Route 84, Interstate 84, but the solution is the defendant, by recruiting a friend, can remove it. So there's never any need to take it into custody.
Yeah, but in that situation, Your Honor, the Opperman rationale of, fear that items may be lost or stolen, or fear that there may be a dangerous item in the car, doesn't apply with the same force, right? I mean, what we're concerned with is a scenario where the police are involved in creating a situation where there is a tow, and then as part of the towing process, there is either a claim of lost or stolen items, or there's a situation where the car contains a dangerous item which could present a hazard to the tow truck driver or to the trooper or to some other member of the public. So in the scenario of the friend in the car who can drive it from the scene, we just don't confront the same constellation of Opperman factors. And it's just a different community caretaking balance entirely in that situation.
Thank you.
Thank you.
Attorney Lockhart, you can mute at this time, and Attorney Lauer, please introduce yourself on the record.
Good morning, and may it please the court. My name is Scott Lauer. I represent the appellee Pablo Rivera. The district court's grant of suppression should be affirmed because the district court correctly concluded that the community caretaking function was not served by the actions of the government in this case.
Mr. Lauer, let me ask you, how does your case differ from the parameters of the state police policy that's been introduced at the hearing?
Well, Your Honor,
or does your case fall within the literal parameters of that policy?
I think the answer is that the policy regarding the need to tow vehicles from the highway does require the officer or direct the officer to inventory the vehicle. However, the inventory policy, which is a separate policy, speaks to the circumstance that we were just discussing with Mr. Lockhart concerning a motorist who is able to arrange for his own tow or his own.
How is this case like the case of the motorist who can arrange for his own tow?
This case is like that because the vehicle is disabled in a sense, and that's the word that's used by the policy.
Right.
And
the towing company was selected by the trooper.
Yeah. So
and the
Mr.
towing company was called by the trooper.
In this case, the trooper did not afford Mr. Rivera the opportunity to do that. He called
Yeah,
interstate.
so we've got a towing company that's selected by the trooper, called by the trooper, coming to the scene at the trooper's request. So I'm struggling with the notion of why that's not quintessentially within the parameters of the policy.
Well, it may be on a literal reading of the policy. It may fall within the policy. But as I believe Justice Barron brought up earlier, the policy itself is not.
You mean Judge Barron? The
Excuse me,
justices
Judge
are
Barron.
all down on the Potomac, not here.
Pardon me. Yes, Judge Barron brought up earlier that the policy itself is not necessarily determinative of whether it is a valid search under the Fourth Amendment.
That's true.
So the policy may be perfectly reasonable in other instances and unreasonable in this instance. And that is the argument that we presented to the district court, was that the circumstances, the facts and circumstances of Mr. Rivera's stop and the ensuing search differed from those in many other reported cases. In nearly all of the reported cases, there are legitimate governmental interests that are served by the decision to either impound and subsequently search the vehicle. That is because in ordinary cases, or the usual case, the defendant is arrested and the vehicle is not left in the custody of a third party. The defendant is not in a position to safeguard his own property. And so that's a critical distinction in this case. And that's the sort of distinction that the district court drew in deciding the case.
How was the defendant in a position to safeguard his own property?
Well, he was told by the trooper that he was A, not under arrest, and B, that he would be accompanying the vehicle.
No, he wasn't told that he would be accompanying the vehicle. He was told that he had the option to accompany the vehicle. Isn't that so?
It may be that he was told that he had the option to accompany the vehicle, but it is unquestionably the case that he was not under arrest.
No, that's true. And he never responded when I mean, you know the record, presumably better than I do. But from what I can tell from the record, he was told that he could accompany the vehicle to the tow company. He could ride with the tow if he chose. And he never responded to that. At least there's nothing in the record that I've seen that indicated that he ever said, I'll do that, or that sounds great. He just didn't respond.
I think that's an accurate summation of the record. And, okay. And the point that I think the trial court drew from that, and that I would urge this court to draw, is that is a differentiating circumstance from the ordinary inventory search case. The court here looked at Opperman, looked at the governmental interests that are cited in Opperman, saw those interests not present in this case. And on the balance of the Fourth Amendment factors and correctly concluded that this search was not a valid exercise of the community caretaking function.
You're focused on the, go ahead, Judge Gada.
Yes,
Suppose when the tow company suppose the officer did not do an inventory search because he'd offered the option to ride with the tow company. He got in his car, and then after the tow company came and hitched up the car, the defendant said, you know, I'll go with you, officer, instead, and dropped in the back seat of the officer's car. What would happen then? Would the officer have to get out and do the inventory search then, after the tow is already there?
No, I think unless the vehicle is in police custody, there's some reason to think that the police might be liable for property that goes missing.
But the tow company's acting at behest of the police here.
That's true, but
suppose when he picked up the car, he announced, you know, I had $5,000 in the back seat of that car. It's missing. And if a jury believed him, wouldn't the tow company and or the police be liable for $5,000 because they couldn't prove it wasn't in the car?
Well, I think in the first instance, it would be the tow company's problem and not the problem of the state police. But certainly that sort of danger to the police is sufficiently attenuated that it is not a strong, compelling government interest of the nature to support an infringement of the defendant's privacy rights.
Why is it attenuated? Why is it attenuated at all?
Because
I mean,
if the police are not in the vehicle,
right?
They are not, the idea that they can be somehow held liable for property that goes missing when it's in the property of a third party is more attenuated.
But the third party is their agent operating at their direction. And one of the purposes of the inventory search is to make certain that claims of quote missing, close quote, property like that can't be leveled or can't reasonably be leveled. And the scenario you offer provides the police no protection at all from that. Even if Mr. Rivera had elected to accompany the tow truck to the garage, he might then simply have left. He might not have had the money to pay for the tow or whatever circumstance. And we might have had the same circumstance of an uninventoried vehicle being left in the tow company. And as Judge Kayada said, subject to whatever claims were then subsequently made.
I suppose there is that possibility. Certainly the tow company would not be directed to remove any property. Certainly, if the state police place the vehicle in the custody of the tow company, they're not doing so with the authorization for the tow company to remove any of the property. So in this case, as you rightly pointed out, the defendant did not, there's no evidence on the record that the defendant either elected to go with the tow or didn't. One could certainly read his lack of response as acquiescence. And on a fundamental level.
How could one do that?
When if a Massachusetts State Police trooper who has informed him he needs to sit by the side of the guardrail, then tells him that he has the option to ride with the tow, he didn't voice his dissatisfaction with that.
He didn't say yes or no. So I don't see how you can read anything into that other than he's thinking about it.
Well, I suppose it's a question of how far that silence can be taken. But on a fundamental level, what we have here is a search that is different than the inventory searches in the vast majority of cases. And the district court looked at those circumstances and correctly concluded that they were not served by the actions of the government.
Judge Barron, did you have a question?
No, I think I'm okay.
Thank you.
Thank you, Mr. Lauer. You can please mute your device at this time. Attorney Lockhart, if you could unmute your device and introduce yourself back on the record.
Yes, Donald Lockhart again for the government. I'd like to follow up on a point that Judge Selya made. Let's just assume hypothetically that the record makes clear that, in fact, Mr. Rivera was going to ride with a tow truck. Even under that scenario, the Opperman factors still apply because there is still going to be not just a risk of dangerous items in the car, but a risk that items could be lost or stolen, or that Mr. Rivera would claim that that was the case. And I'll give you three scenarios in which the loss or theft could play out. The tow truck driver arrives. Mr. Rivera gets in the passenger seat of the truck. Meanwhile, the tow truck guy is winching the car up onto the ramp. He needs to put the car in neutral to do that, and goes into the car, sees the watch on the seat, puts it in his pocket. That's scenario number one of where the fact that Rivera is with the tow truck is not going to demonstrably change the risk of theft. The other scenario is they arrive at the tow truck yard. Mr. Rivera gets out of the tow truck. He says, I want to use the men's room. Again, the tow truck driver is left alone with the truck. The third scenario is the one that Judge Selye alluded to. Rivera says, you know, I don't have the money right now to pay for the towing. I'll come back tomorrow with my cousin who can drive the car. We'll pay you at that time. So the car is left at the lot overnight. Colorado versus Bertine makes clear that this theft or stolen items rationale applies not just to claims that may be directed later on at the police, but also claims that may be directed later on at the police deputized towing company. So that's our response to the defense suggestion and the district court's suggestion that somehow the courtesy extended to Mr. Rivera that he could potentially ride with a tow truck if he so chose somehow alters the analysis. If the court has no further questions, we'll rest on our brief.
Thank you, Mr. Lockhart.
That concludes the argument in this case. Attorney Lockhart. Thank you. The next case today is Lisa M. O'Rourke versus Tiffany and Company, appeal number 20-1404. Attorney Dickinson, please introduce yourself on the record.
Attorney Thomas Dickinson for the plaintiff appellant Lisa O'Rourke. Good morning. May I proceed?
Yes, you may.
Your Honor, may I reserve 3 minutes for rebuttal?
Yes, 3 minutes.
Good morning, and may it please the court. This is an appeal from a grant of summary judgment in an FMLA case. My client, the plaintiff, Lisa O'Rourke, was an employee at Tiffany's facility in Cumberland, Rhode Island, where she began her employment there in the year 2010. She found in 2013 that she suffered from a genetic condition called BRCA2, which necessitated a series of surgeries in order to prevent her from suffering from cancers. So in late 2013, she sought a medical leave for the first of these surgeries, which was granted, and she was on leave from her position from mid-January to mid-May of that year. Later that year, she needed a follow-up surgery in order to follow up on some of the procedures that she had had. And she requested that leave in July of 2014, and she was out for a little less than a month between July and August of 2014. Then again, in the fall of 2015, she needed to have yet a third surgery in order to deal with some problems that had arisen in the first and second surgeries. And so she requested a third leave, which would have taken place in January or early 2016. She requested that leave in October of 2015, having told her supervisor a few weeks earlier that she was going to be formally requesting it. She did formally request it in October of 2015. All during this time, or at least when Ms. O'Rourke was on her first leave in early 2014, a new vice president came on board at Tiffany's in New York, Mr. Wayne Howard, who had supervision over the facility in Cumberland, at least the portion of the facility where Ms. O'Rourke worked. Mr. Howard was the vice president of manufacturing. And the evidence shows, and I submit that the basis for Ms. O'Rourke's claim is a series of events involving Mr. Howard, which demonstrated his animus towards her as a result of her having taken these needed medical leaves. This animus began before he even met her, while she was on leave in 2014, when he questioned, first of all, her excessive absenteeism, and when she sought a second leave later in 2014, he referred to that leave as unfortunate, and he told her supervisor, or he told personnel in any event, and her supervisor, that they would have to be carefully evaluating her performance. Also during this time, he questioned her high employee rating, even though he had not yet worked with her. He falsely claimed that it was common for him to question high ratings, but he admitted in his deposition that he could not recall ever questioning another employee's high rating.
Mr. Dickinson, that email in text, you seem to, he said he wanted to, had concerns with her performance, he wanted to do a review, and it was the context of that he then said, unfortunately, she will be out again. How is that showing? I mean, it was unfortunate she was going to be out again.
Well, that's certainly one inference that you could draw from it, Your Honor. However, at this stage, at the summary judgment stage, the view of the evidence in the language of this court has to be in the most hospitable light to Ms. O'Rourke. And I suggest that given Mr. Howard's other statements and other approaches to her or treatment of her, it's certainly capable of supporting an inference that he saw the leave as unfortunate because she was going to be out and because he didn't want to have an employee out whom he had already questioned about excessive absenteeism. And that taken together with the fact that he didn't question the performance of any other employees, or I should say he didn't question the reviews of any other employees, or at least none that he could recall at the time that he was deposed.
Could you remind me what the context of the excessive absenteeism statement was?
I'm sorry.
Could you remind me what the record shows about the statement where he questioned her, quote, excessive absenteeism? I thought that's not the language of the employer who says that, the supervisor. I thought that was the language of counsel describing what he said. Is that wrong?
I may not have that clearly in my memory, Your Honor, but my recollection is that he questioned her absences from work, and my recollection was that he questioned that to her supervisor.
How did he question it? I'm not seeing that as I look here.
I'm sorry, Your Honor. I don't have a record reference right in the front of my mind on it, except to say that he certainly did call the leave unfortunate, and he
definitely said it was unfortunate she wouldn't be there so that he could review her performance, which is not the same necessarily as saying that the leave was unfortunate.
Well, I think either inference can be drawn, and I submit that.
I get that, but then you say, but one thing that would tip the inference and make it not speculative to say that it was a hostile statement is the fact that he otherwise questioned her absenteeism. So I'm just think that's a pretty critical piece of evidence for you, and it'd be helpful to know what that evidence actually shows on that score.
I will track that down before my rebuttal, Your Honor. So the other thing that he did, and I think this is an important point, the other thing that he did is he created a new position for her. So she's had her first leave in 2014. She's had her second leave in 2014. And towards the end of 2014, he now creates a new position for her within the same unit, but a new position. She goes from being director of purchasing and planning to director of strategic sourcing. Within a year, he decides that he needs to eliminate that position. And his explanation for that at his deposition is that the position made no sense. So one could certainly...
Excuse me, counsel, did the director of purchasing position continue to be filled by someone else?
My understanding is that he changed the position. He created a new...
So that her position as director of sourcing encompassed or included her previous duties as director of purchasing?
Yes, yes, it did.
Okay.
And then
5 minutes remaining.
thank you. And then he says in deposition, when explaining why within a few months, I mean, it was well within a year, he begins to decide that he's going to eliminate that position. He says it's because the position made no sense. This is a position that he created and created specifically for her. And so I think from that one can infer, and there was a suggestion in the record that this was not the first time that he had created a position for somebody for purposes of eliminating them.
Well, what was the other? You say there's a suggestion on the record he did that before. What are you pointing to?
I believe there was testimony from one of the other, I believe there was testimony from Ms. O'Rourke that her supervisor had told her that he did this before.
But that's not admissible evidence.
Well, it supports the inference, whether it's admissible or not. It again demonstrates a pattern on his part.
How can it demonstrate a pattern if it's inadmissible?
Well, I mean, it's admissible for purposes of showing a pattern. And
so what's the legal principle here? Evidence that is otherwise excludable as hearsay is admissible for the purposes of showing a pattern?
Well, it's not
What's the authority for that?
I'm sorry, Your Honor?
What's the authority for that?
Well, I think it certainly shows whether it's admissible or not, and whether it can be considered by a jury or not. It certainly tells Ms. O'Rourke that this is a practice that he has engaged in the past, and whether he had engaged in it in the past or not. This particular episode, where he creates this position for her after having been concerned about her leaves and having described them as unfortunate and having told her supervisor that she needed to keep an eye on her and watch her closely, he creates a position for her and then within 10 months eliminates the position as a basis for terminating her, saying that the position made no sense. The position that he created for her. So he's put her into a position that makes no sense. And certainly that supports the inference that he did that for purposes of eliminating her.
Well, it might, if there was some evidence he was concerned about her leaves. So I think that it is, I mean, when you come back, it would be helpful to me to know what is the evidence that indicates he was concerned about her leaves beyond the use of the word unfortunate.
Well, and the fact that he said that she needed to be monitored closely. And there were other things that he did. He blamed her for inventory problems.
Yeah, but we're trying to figure out why he was concerned about her conduct. If the reason was that she was taking leave, then you have a case. If it was not because of that, then you don't. So
yes, and I think that's a jury question, because we do have some evidence of it. And the question is whether or not the other pieces of evidence fit together with that evidence to support.
Still, just to reiterate the point, the some evidence seems to be the unfortunate reference, and then some other evidence you need to identify, which shows a concern about excessive absenteeism.
Well, and also the manner in which he directed that she be closely monitored, the fact that he
evidence about a concern about her leave taking.
Well, it certainly could be. Of course, if that's what his concern is, that her leaves are unfortunate, that he's criticizing her for things that are happening while she's on leave, it certainly could be, and a jury could so find. And I think what the judge did here, and what we have to be cautious about, is parceling all these pieces of evidence into little segments and treating each of them as if they independently have to support a conclusion that there's a causal connection here.
If she had a heart attack and he told her boss that was unfortunate, would you suggest that a jury could draw an inference from that he was against people who had bad hearts?
Taken together with everything else that he did with regard to her? Yes, I might well.
But when you say taken together with everything else, then that leads us to, well, what's the what else? And I'm not hearing it here.
Well, there's the telling that she needs to be closely monitored. There's the blaming her for inventory problems that occurred when she was on leave. There's the falsely or inaccurately blaming her for an employee who left. who he initially held against her.
That's time.
Thank you. Have I answered your question, Your Honor?
Thank you.
At this time, if Attorney Dickinson could mute his device, and if Attorney Collier could unmute her device and introduce herself onto the record.
May it please the court, I'm Stacy Collier. I represent the appellee Tiffany and Company in this matter. Your Honors hit it right on the head when you were addressing the question essentially of pretext plus here. There really is nothing to demonstrate that Wayne Howard had, first of all, any knowledge of Ms. O'Rourke's specific medical issues, but in addition, the information and the evidence that Attorney Dickinson points to does not lead to any sort of inference that there was anything other than legitimate non-discriminatory or non-retaliatory business reasons that led to any of his conduct or decision-making regarding Ms. O'Rourke. The excessive absenteeism reference that you're referring to is on page 180 to page 181 of Mary Messier's deposition testimony. And you are 100% right. That was based on the characterization of Attorney Dickinson's co-counsel in Ms. Messier's deposition testimony, where she characterizes it as a question of whether Mr. Howard was concerned about excessive absenteeism. And Mary Messier says, I wouldn't say concerned, he asked, but, and then it was never picked up on again. So there's nothing in the record to suggest, other than counsel's characterization, that Mr. Howard made any sort of reference about excessive absenteeism with respect to Ms. O'Rourke.
Can I ask you, the one point that concerned me in the record was I guess Mr. Martin, who was there for 2 weeks and then left, is that right?
Yes.
And it does seem that Howard is concerned about the way Martin was treated, even after he's been informed by the person who observed their relationship that there's no reason to be concerned about how he was treated, given how difficult Martin was. And nonetheless, even after being informed about that, he seems to stick on this idea that somehow O'Rourke is the cause of that early departure. Couldn't a juror conclude that that just doesn't make sense and that something must be motivating that other than the facts?
I think there's certainly a record that he had asked about, and he had some concerns about the sourcing function and certainly Mr. Martin's departure. I think it would be of greater concern if Ms. O'Rourke was terminated for performance reasons. There's nothing on the record to suggest that anything other than the elimination of her position for an organizational restructure is what drove Mr. Howard's decision-making.
Let me just play that out. I guess most favorable to the plaintiff, if I'm understanding the argument, would be something like this. He's aware that she took leave.
He's aware that she took leave.
So the ADA, putting the ADA claim aside, for the FMLA claim, did he retaliate against her because she took leave? Well, part of the rationale for why he moved her into this position that then turns out not to be necessary had to do with the, you tell me if this is wrong, downgrading of her performance. And one of the reasons given for the downgrading of the performance was her supposed poor supervision of Martin, even though the record gives good reason to think Martin was to blame there. So why is Howard downgrading her performance for that reason? What's your answer to that?
Sure. Well, first of all, he never made the decision to change her position in 2014 because of a downgrade of performance. It was because Mr. Howard was taking a very critical look at all of the areas under his supervision and made a bunch of changes. The idea that he created this position to only move her out of it pretextually is not supported by the record. 10 months had passed. He was trying to make the resources that he had available work in Cumberland. After giving that an opportunity to see if it would be successful, it was not a successful deployment of resources. It did not make sense to continue to have a group with 2 directors and 4 reports. He reorganized, restructured, put a lot of the duties with Ms. Messier as well as with Alok Dar in New York.
But I'm sorry, I guess I thought, maybe I'm wrong, I thought the record suggested that once she's downgraded to a 4, as opposed to getting a 5, that's when suddenly there's an indication she might be at risk of staying around. And then there was, I thought, a discussion about, well, maybe we should keep her on and try her out in this role. Is that wrong?
No, that's not consistent with the record, Your Honor. Her position was, when we say downgraded, let's be very clear. She was downgraded from a 5, which is exceeds expectations, to a 4, which is always meets expectations, sometimes exceeds expectations. So her speculation that she went from having an excellent record to being viewed as poor is not consistent with the record or how Tiffany manages performance. It was still a very good rating. She earned the same merit increase she would have earned as a 5.
But just one last passage. I thought there was record evidence that Howard had a conversation with someone else about O'Rourke, in which Howard wanted to take more adverse action against her and was told, well, maybe we could try her in this new role where she would stay on. Is that wrong? Is there no such evidence like that?
So there's evidence following his making the decision, which was communicated on October 7th. There was a question when he restructured and there was a lower level position available. Then yes, she was considered for that position. And I, in fact, offered that position. So she was offered the choice of accepting the position elimination and a severance package.
Oh, I see. But that's after they have already done.
That was after, yeah.
Okay.
And in fact, going back to the earlier change in 2014, she testified that she viewed that as a promotion. So she did not view that as a demotion at that time, if we're talking about the original change that Attorney Dickinson is alleging was problematic. You know, I think what's dispositive on this case is really Howard's knowledge or lack thereof about the reasons that she was taking leave, the specifics of her disability. There's no dispute in the record on the fact that he did not have that specific information. The recently decided case at this circuit of Brader versus Biogen affirms this circuit's view that the decision maker needs to have that knowledge in order to make a decision based on disability. And there was a passage of 16 months between her FMLA leaves in 2014 and the decision that Mr. Howard needed to eliminate her position in the fall. That eliminates any causation between those two decisions. So we feel very strongly that Judge Smith's decision was well-reasoned and should be affirmed.
Thank you. Judge Selya, Judge Barron, any more questions?
All set.
Thank you, counsel.
Thank you.
Attorney Collier, you can mute your device at this time. Attorney Dickinson, please reintroduce yourself back on the record.
Yes, thank you. Attorney Dickinson for plaintiff appellant O'Rourke. A couple of points. First of all, in response to the question about excessive absences or excessive absenteeism, I will defer to my sister's recollection of the record on that in terms of how that came up at the deposition. I think it's interesting, the argument that he didn't know what her condition was. What inference do we draw from his statement about unfortunate if he didn't know what her condition was? I think that supports the inference that he thought it was unfortunate that she was taking the leave, not that it was unfortunate that she had this particular condition. There were a few other points I wanted to mention. I did make reference in the brief and the reply brief to the privilege log, which the trial judge ignored in his grant of summary judgment. I would suggest that the privilege log, which appears at pages 44 through 49 of the appendix, demonstrates that at about the time that this position was being eliminated and that Ms. O'Rourke was seeking her additional leave, they were aware that there was an FMLA issue here. Now, we don't have the contents of these communications because Tiffany has chosen not to share them with us as their right, as the magistrate judge ruled. But
when you say at about this time, do you mean after Howard made the decision?
After Howard purportedly decided, but before the decision was executed, and before a final decision was made within Tiffany, at least that's what we can infer from the privilege log, that Howard may have thought he was going to do something. Frankly, I'd say Howard made that decision as early as January of 2014, when he created, or December of 2013, when he created the new, December of 2014, when he created the new position for her that he decided didn't make any sense. But the privilege log demonstrates that there were discussions about FMLA, that the decision had not finally been made because it was still an ongoing conversation within Tiffany. And in fact, they did make an offer of another position. And the offer of the other position, I suggest, again supports the inference that we're asking you to draw, or that we asked the trial judge or a jury to draw. This was a phony position. It had never existed before. It had not gone through payroll. I think the testimony was that nobody knew where the money to fund it was going to come from because it wasn't anything that existed. When she didn't accept it, when Ms. O'Rourke didn't accept it, they didn't advertise it and they didn't fill it. So clearly it was a pretext in order to soften the notion of what they were doing to her. And I would suggest when you take all of those inferences, remembering that a brick is not a wall, as Professor McCormick said, when you take all of those inferences, as you have said you must, most hospitably to Ms. O'Rourke, that it was wrong to grant summary judgment here. A jury should be permitted to consider this evidence and draw what inferences counsel can persuade it to draw. It is not a question for the judge. This is a question for a jury. And
That's time.
all Ms. O'Rourke is asking for is that opportunity. Thank you, Your Honors.
Thank you.
That concludes argument in this case. The next case today is Francis X. Lang versus Douglas DeMoura, appeal number 20-1099. Attorney Greenberg, please introduce yourself onto the record.
I'm Ruth Greenberg on behalf of Mr. Lang. Judge Kayada, if it's all right with you, I'd like 5 minutes maybe for my case and then 10 minutes for rebuttal. I know it's unusual.
Yeah, why don't we do 4 minutes? We'll be fine.
Thank you. 4 minutes which way? 4 minutes
Well,
for case and
For rebuttal, yes.
okay, thank you, Judge. The reason that I split it that way is because my case in chief is simple. There's just a lot of distractors. This is a pretty straightforward application of Strickland, which requires only 2 things: that the performance of trial counsel be deficient and that the defendant be prejudiced thereby. The last reasoned judgment of a court in this case was Judge Lang's three-judge concurrence, and we're in agreement, the Commonwealth and I, on this. What's wrong with Judge Lang's three-judge opinion is that it adds stuff to Strickland. It makes the Strickland burden much higher than what Strickland makes it, and when it does that, it's beyond incremental. It's really wrong. Strickland's, there is no, what Judge Lang said here is basically that trial counsel's performance was deficient. I believe that that's owed some deference by this court as a fact finding of the court below, but even if it weren't, it's pretty clear trial counsel's performance was deficient because this is a homicide case and the issue was all about the defendant's state of mind and the defendant's intent. It's not, as my sister has argued, a case, an all or nothing case. It was all about what was the defendant's state of mind, what was his intent, did he have malice, and did the Commonwealth prove beyond a reasonable doubt the absence of provocation, the absence of excessive force. These things under Massachusetts law all have to do with the defendant's state of mind. And the jury cared in this case because this was brought both on a theory of cruelty and atrocity and as a deliberate premeditation case. And the jury found on the evidence presented that the defendant did not deliberately premeditate. So you can have cruel and atrocious murder satisfy the requirements of cruelty and atrocity in Massachusetts.
Let me ask you just a question. This is what bothers me. Suppose I thought the performance was deficient because no investigation was done. You can't make a good strategic judgment if you don't even know what the facts are. And let's say we then conclude, okay, so now we get to the prejudice prong. But the unusual thing about this case compared to the ordinary case is it's not a foregone conclusion that at the end of that investigation, that evidence will get to the jury because the counsel then has to make a choice. Now knowing what I know about the investigation, if I did it right, would it make sense to present that evidence to the jury or not, given that I'm thinking there's a pretty good self-defense argument, which if I win on, he doesn't go to jail at all, and an argument that would relate to his mental state, arguably, is in some tension with that because it's about a defense in which he would go to jail for some period of time. Now, wouldn't the prejudice question, since that judgment by the lawyer still has to be made, wouldn't it make sense to think of the prejudice question as, well, is it reasonably probable that faced with this evidence, the lawyer would have presented it to the jury? And yet, when I look at the record, I don't see what indicates that the lawyer here would have done that.
Well, what we do is we look at what the lawyer did, not what the lawyer said he would have done, because as Justice Lang pointed out, we're not looking at these things with the benefit of hindsight and self-justification. We say, what did the lawyer do? And what the lawyer did here is he presented a mitigation defense. He argued that the defendant was impaired by alcohol. He argued provocation manslaughter, which has a subjective and objective component. He argued mutual combat, which has a subjective and objective component. And he argued excessive force and self-defense, which also has to do with what the defendant actually perceives as well as what a reasonable person perceives.
So I guess you think at the prejudice stage, it's of no consequence that there's a discretionary judgment to be made? But we know that a lawyer has discretion in a I don't think it would be deficient performance if after the investigation that turned up this evidence, the lawyer still didn't put it on. Do you think it would be?
It would depend on the facts of the case and the argument the lawyer
Well,
would.
this case with the evidence we have about what the investigation would have turned up, would it have been deficient performance not to put that evidence to the jury?
It would have been deficient performance not to consider working.
No, that's not my. I understand that. That's not my question. Would it have been deficient performance not to put this evidence before the jury?
Yes, it would have been deficient.
Okay. Now let's just assume that I disagreed with you on that. Okay. And I thought that would not be deficient performance. It would be deficient performance not to have done the investigation. But if I did the investigation and I learned this about the mental history, and I had this evidence of self-defense with the evidence of alcohol, suppose I thought it would be a reasonable decision for a lawyer with that conjury of evidence to say, well, I'll go with some evidence about the drunkenness and I'll run my self-defense argument, but I'm not going to put forward evidence about the mental health issues because I don't want to open that box. If I thought that was a reasonable judgment, then why at the prejudice stage wouldn't I have to take account that a lawyer could make that reasonable judgment in trying to figure out whether it's reasonably probable that the failure to conduct the investigation resulted in prejudicial outcome to the defendant? I have trouble seeing that.
I understand your question, Judge. The way that this lawyer did
5
this,
minutes remaining.
the way this lawyer presented this case and this argument, it was prejudicial to the defendant and deficient performance not to present evidence of this mental impairment. The mental impairment was so extreme. The evidence was, not just by our own expert, but by the 17-year history of mental health, that the defendant was unable to interpose thought before action, that his as measured on standardized testing, he was the bottom one of 1,000 people for self-control, that he was removed from his medication and wandered sleepless without meds that he had been taking for years, that he had been treated with Remeron, Seroquel, Depakote, a panoply, all of which were removed from him. In any reasonable lawyer presenting the argument that the man couldn't control himself because he was drunk would
now,
also...
Can I ask you, if I understand Justice Lenk, she was focused in significant part, and maybe I'm misremembering it, on the statement from the petitioner that he didn't want to go to Bridgewater, and he didn't want a defense about his mental state, and use specific words that just may matter. What's your answer on that for to the fact that he doesn't want to go to Bridgewater, and I guess the more he makes the case for his mental health problems being a cause of why he had diminished capacity, the more likely it is that he's going to end up in Bridgewater?
Well, setting aside the quality of that evidence for a further discussion, there are many uses for mental health impairment defense which don't result in Bridgewater. Bridgewater in Massachusetts is where you go if you're found not guilty by lack of criminal responsibility. But it's not where you go if you're found guilty of provocation, manslaughter, where the subjective crime is satisfied by the fact that you perceive things in a different way or have a different reaction time or a different ability, level of subjective provocation. You don't go to Bridgewater if they fail to prove you have the mental intent required for malice. Mental impairment goes to all the factors of cruelty and atrocity. Not arguing none of those things would result in a Bridgewater.
Last question, is that your understanding that Justice Lenk's opinion on prejudice is dependent entirely on what the petitioner desire was about the use of that evidence?
Yes. Judge Lenk.
And so if we thought that was error, if we thought that was unreasonable, then what we would do de novo review of the prejudice inquiry?
Yes, because Judge Lenk found no prejudice for two reasons. Most particularly, she found no prejudice because the defendant, through his counsel, that would be me, would not bind himself to a future course of action. And that's nowhere in Strickland. That's a post-Strickland original requirement, which is 0. And there's also no requirement in Strickland that a defendant agree to do something, has to affirmatively prove that he would have used evidence which was admitted in the second time or even in the last time. If a reasonable lawyer would have used that evidence, that would have been a decision, as you say, that's up to the lawyer. It's not up to the defendant.
Well, if we could
Go ahead.
step back a second, I had thought that it was in the record that this was one of the most skilled and experienced criminal defense lawyers in the state of Massachusetts, and that he indicated, based on his experience, this type of defense wasn't a good defense. That seems on its face to make some sense. Telling a jury a guy might have had a few more beers on some evening is one thing, but telling a jury that a person doesn't have impulse control can blow up on you in a case. So how do we conclude that a judgment that sounds like it was reasonable, which is there's no way I would have presented one of these defenses, how do we find that's just not true?
So that I'm willing to credit Attorney Sheketoff is widely experienced. He's made this exact same mistake before, though, in Commonwealth versus Rivera. It's not correct. It's deficient practice to say that in no instance will I present a mental health defense. It particularly where you're arguing mitigation anyway. It's simply the fact that you don't like them. It's the same as a lawyer saying I would never present DNA or I would never present alibi. These defenses exist as a matter of law. And when we refuse, a lawyer can't simply remove 30% of his toolbox, particularly in the case where intent is exactly the thing that the jury's questioning, where malice is the issue, where provocation is the issue. We can't say, I depart from that toolbox. When you look at the transcript of this case, and this is actually the only time in my experience the motion judge refused to look at the transcript. We have 9 volumes of testimony and 1 witness supporting perfect self-defense.
I guess I'm just confused how you think the analysis should proceed in the following sense. There's one form of sufficient performance which seems to have been recognized by the 2-judge opinion of the SJC, which was the failure to investigate. You're then saying there's a second level of deficient performance, which is post-investigation. If it turned up this evidence, it would be deficient not to use it if you were otherwise putting it in the capacity evidence forward.
Yes, you have my argument.
Okay, was that second level of deficient performance that a first prong Strickland point, or is that a prejudice Strickland point? Because it seems embedded in it is not your typical prejudice finding. That's a finding about deficient performance itself, about which the SJC never passed on it. I don't quite know how to think about how you do that on habeas review.
We split it into 2 parts, just like Strickland does. Clearly, we are all in agreement. At least the 3-judge panel of the SJC was in agreement, and I don't think there's serious dispute that Bob Sheketoff deciding I don't do mental health defenses, so I'm not even going to look at the safety in your record was deficient performance. Second, we look at whether he was harmed by it, and we say here,
but what I'm saying, you're saying the predicate for finding that he was harmed is a second determination that it was deficient performance not to put it forward. Suppose we thought it wasn't sufficient performance not to put it forward if I had seen this evidence, knowing all the particularities of the case, I just decided I don't think I'll go forward. Is there still prejudice, or is the only way we can find prejudice is if we determine that judgment itself to be deficient performance?
Yes, the harm is the failure to put it forward. The harm is the failure to make a reasonable decision whether or not to put it forward. That's the prejudice, which the SJC doesn't address, because the SJC is blocked by its failure to recognize that mental health evidence can be used to reduce and to mitigate without sending a defendant to Bridgewater. So the SJC doesn't address it, and because it requires this weird promise about future trial. So this court looks at de novo on whether or not the defendant was prejudiced by the fact that Bob Sheketoff decided, I don't ever do mental health evidence. Because it wasn't, and I'm going to go back to Judge Ayala, that he said in this particular case, weighing and balancing, I'm not going to do it, looking at my client individually. Instead, what he said was, I don't do that. I don't look it up, and it wouldn't.
I'm sorry, Judge. It seems that she's frozen and perhaps has dropped out of the meeting. I think.
Just saying that Mr. Sheketoff saying he would never do it in any case was the problem. He didn't make an individual decision here.
Yes. And had he made one, he would have used this evidence. And any reasonable lawyer would have, making the arguments that he did.
Thank you.
Thank you, Attorney Greenberg. You may mute your device at this time. And Attorney, I'm sorry, Attorney Granick, you may proceed. Please introduce yourself on the record.
Good morning, may it please the court. Assistant Attorney General Maria Granick for the respondent appellee. I would like to start with the prejudice prong discussion that my opponent began here. And I'd like to point out that, first of all, Justice Lank's opinion on prejudice did not rest only on the idea that the petitioner was not willing to present mental health-based defenses, but it was also based on the view that even if he had agreed to present a lack of criminal responsibility defense or other type of mental health defense, he would not have been a substantial defense. And so there's no reasonable, as I'm quoting from the by the court opinion of the SJC, there's no reasonable basis for thinking the outcome of trial likely would have been different. So in that sense, Justice Lank's opinion, which is the majority opinion here, and the Zoe deference on habeas review under AEDPA is not unreasonable. Under AEDPA, the petitioner must show far more than that the state court's decision was merely wrong or even an error. He must show that it's beyond any possibility of fair-minded disagreement. And here, the petitioner simply has not shown that. Justice Lank's opinion on prejudice encompasses these different considerations, and it is not unreasonable. So more generally, this court should affirm the district court's denial.
On that second theory of prejudice, how, given the evidence of his significant mental health issues, how could we say there's not a reasonable probability that the jury would have believed it?
So again, there's can be at least fair-minded disagreement. It's reasonable to say
well,
that.
That's what I'm saying. How, given that it doesn't have to be, dead certainty that the jury would have bought it. It just has to be a fair probability, a reasonable probability that the jury would have been influenced by it. Under Strickland prejudice, and then we do it through the deferential lens of, could one think that they wouldn't have, what would be the basis for thinking that, given how strong the evidence of diminished capacity was based on mental health, how would we have a reason to think a jury, I just don't follow. What would be the ground for thinking that?
Here, first of all, we have to keep in mind that there was a strong self-defense theory presented at trial, and that mental health evidence would have been inconsistent with that self-defense argument.
So we don't know which way that inconsistency would cut. In fact, the lawyer was worried the inconsistency would lead them maybe to buy the diminished capacity and not focus on self-defense, which would be the better defense for him, because he would get off entirely. So, I mean, that cut against the notion that the jury would have not been moved by the diminished capacity offense. I mean, that, I thought, was partly why the defense counsel didn't want to put it forward, because it would be inconsistent with self-defense, which was a more
I think that counsel's decision to pursue the self-defense theory, which was supported by a witness and which was consistent with what his client was telling him had happened, was because he thought this was a stronger and more viable theory. And the petitioner has now shown that there's a substantial likelihood of a different result had the jury been weighing the mental health evidence instead of weighing the evidence of the altercation that occurred and what his client had done in responding, according to his own account of what had happened, to being attacked by multiple people, to being beaten. And counsel was focusing very strongly on this idea that his client had a reasonable apprehension of great bodily harm and a reasonable belief that no other way of preventing the harm existed. And diminished capacity would have required him to most likely put expert opinion about his client's mental illness before the jury, and potentially had undermined his credibility in making this argument that his client was, a relatable person who was what he perceived.
Right. But that's only if they would believe that evidence from the expert. But if they believe the evidence from the expert, that sort of suggests that maybe they'd find he had diminished capacity. So then I don't see how you can say the second theory of prejudice makes sense. That's what I'm having trouble with.
You can assume that they would have believed the defense expert. What would have happened was the jury would have been exposed to the opposing opinions of the prosecution's expert, who would argue that, in fact, the petitioner's behavior was rational, that he tried to walk away, that he knew what he was doing, that his mental illness did not prevent him from being able to act reasonably in that situation. And the petitioner just hasn't shown that having that conflicting evidence before the jury would have resulted in a net gain for him, which is what he has to show in order to demonstrate that the finding of no prejudice is unreasonable, again, under this doubly deferential standard. So even if you suppose that some jurists might believe that evidence of mental illness would have been helpful, and even that, I think, is an assumption that he hasn't shown necessarily is true, because again, we have very experienced defense counsel who's trying to weave this argument about his client having had a few drinks in order to kind of have this fallback position about the frailty of human nature and excessive force and self-defense. But he's not really arguing, he never argues to the jury that he was, drunk to a point at which he was debilitated and could not understand what was happening. So he's very carefully telling the story and focusing the trial and focusing the jury in a particular way.
What are we to make of the slightly different standard that Massachusetts uses than the Strickland standard? We have the three judges saying that the failure to investigate did not meet the standard for effective assistance of counsel. But as I understand it, that is different. The Massachusetts definition of effective assistance of counsel is different than the Strickland definition. It doesn't have to constitute conduct falling measurably below those of the ordinary fallible lawyer.
That's correct, and that's one of the reasons why, if this court were to reach the performance prong of the Strickland claim at all, it should address it de novo, because when the SJC finds deficiency, it finds it under the Massachusetts standard, which, as you point out, is more favorable to the defendant, and therefore we don't know whether they would have found deficiency under Strickland.
And then related to that, I'm trying to get my mind around, how do you say that it's a deficiency not to investigate the mental state of a client further, and then turn around and also say that it's not deficient, we're going to deem it wasn't prejudicial because counsel wouldn't have presented it anyhow, no matter what it was? It seems to me a lawyer who is legitimately saying, I'm not going to present this no matter what it is, why would he investigate? Why would we say it's negligent to investigate, to failure to investigate?
I think the main point here is that it's a misrepresentation to say that the counsel's position was he wouldn't present it no matter what, because he actually did make a strategic, and I would argue reasonable decision that in this particular case, presenting it would undermine a strong self-defense that he was choosing to present. And he was, as been mentioned before, very experienced and has presented mental health evidence in various contexts before in other cases. And he believed that here he actually had a strong chance of winning, potentially winning an acquittal based on the self-defense theory. So he is not saying, I'm not going to present it no matter what. He's saying, in this case, I understand there's some mental health history, but I'm not going to investigate it. And there's no duty to investigate in every case when there's a mental health history. So here, he could make a reasonable decision that made the investigation unnecessary, thus making his, again, decision not to investigate not deficient performance, I would argue.
How do we deal with the fact that if I read the three justice opinion, it doesn't address the diminished capacity point as such?
I would say that it does address it, and this court is required to presume that it was adjudicated on the merits.
Well, I understand the second part, but when I read the text of the opinion, there's no analysis that separately addresses diminished capacity in the way it addresses legal responsibility, correct?
There's no explicit analysis of the diminished capacity.
5 minutes remaining.
So does that mean, in your view, we assume under Richter that it would have looked at the diminished, if we thought there was a problem with the way it was doing Strickland along the lines of what your opponent suggests with respect to the legal responsibility argument, we nonetheless are supposed to assume they would have done it the right way and not use that same logic with respect to diminished capacity just because they didn't mention it? That seems strange to me, but I don't know how to. You see what I'm saying? In other words, we have an analysis of how they go. We have their explanation of how they go about thinking about the Strickland failure to investigate and the prejudice question with respect to the legal responsibility argument. We have no similar analysis of how they would do it with respect to diminished capacity. Does that mean we apply Richter and we assume they would have done it the best way possible? Or would it be more sensible to say they would have used the same type of logic that they just showed they would use with respect to legal responsibility?
Well, I think you start with the idea that they reached the conclusion that having the mental health evidence in any form at trial would not have helped the petitioner. And you take that ultimate conclusion regarding prejudice as...
Yeah, but there's two theories she gave on that. One theory, there's two theories that were given as prejudice. One was a theory about it wouldn't have made a difference at trial even if the evidence was there. But that doesn't consider diminished capacity. The other theory was the petitioner didn't want you to use the evidence, but that arguably doesn't address diminished capacity either. So with respect to what the prejudice analysis or the deficient performance would look like as to diminished capacity, it's a black box. We don't know what reasoning would have been used. So does that mean they get the SJC gets the benefit of Richter, and we assume Well, they would have done it in the best way possible. It just seems like an odd situation. They're so closely related.
I think, first of all, you could also look at the petitioner's statement, which the SJC took to mean that he was not interested in pursuing mental health defenses as applying to both criminal responsibility and diminished capacity. And if you look at the statement, it's more clearly relating to Bridgewater, but it also says something like, I'm not a sick person. And it seems to evidence that he was just not interested in pursuing that type of argument. So I think you could apply that to diminished capacity.
Right.
Well,
This is my question. Suppose we thought it's an error, it's an unreasonable application of Strickland to make the petitioner's own view of whether to make that defense with respect to diminished capacity relevant, which is what your opponent says to us. If we agree with that, since we don't have any indication of how the SJC actually analyzed the Strickland issue as the diminished capacity, do I assume that's how they would have done it, or do I assume they would have done it the right way? I just don't know how to think about that.
I would suggest you explain that the right way, and you focus on the fact that they had this argument presented to them, both with respect to criminal responsibility and diminished capacity, and that they found that putting that evidence before the jury would not have made a difference, would not have positively affected how they evaluated the defense theory, and I would suggest potentially would have so if there are no other questions, I would rest on our brief.
Thank you.
Thank you.
At this time, Attorney Granick, if you could please mute your device, and Attorney Greenberg, I believe you have 4 minutes of rebuttal left.
Can you see me?
Yes.
Can you hear me? Don't take this minute from me. I need it. The first thing that I want to talk about is the difference between what's a ruling and what's a dicta. What the SJC decided, and this goes to Judge Barron's question, what the SJC decided here is we're not going to look at prejudice really, because we're going to say he decided he didn't want to go to Bridgewater and he wouldn't promise in the future. That was the ruling of the 3-judge panel. What my sister's talking about is footnote 1 from Judge Plank, which is dicta in a hypothetical. Even if I were, then I might, or I could, I. That's not the court's opinion. That's a random thought following what the court decided. It's what the court might decide in a different situation, but didn't decide it here. Because what happened here is they didn't look at the prejudice, and therefore there is no doubly deferential review. You're the first court to look at whether or not the defendant was harmed, because his trial lawyer, who was already arguing provocation, heat of passion, all those things that go to mental state, in a case that went to mental state, where the jury already found no intent, where you're going to look and you're going to go back into Judge Barron's question again. How can a court say on the evidence here that there was no reasonable probability the verdict would have been altered if the expert had been believed? And then you don't sit on whether or not this expert would have been believed. I mean, if you wanted to, you could. You could say, here's Dr. Spears, who does tests, and here's Dr. Walters, who communicates by telepathy. Which one? And you would say Dr. Spears, but you wouldn't. You would say that's a jury question. But what you have to acknowledge, and what you have to acknowledge, is this isn't defense. This is a qualified witness. If this witness were to have been believed, the verdict would have been different. And there's no reason on this record for this court to sit as a second jury and say basically what Bob Sheketoff does. These witnesses are never believed. You can't say that as a matter of law. This is a defense.
Can I ask you the same Richter question? With respect to diminished capacity, which the SJC 3 justice opinion does not address in any kind of analysis. One possibility is we then say, well, you get the benefit of Richter then, because you didn't say anything about it. So we presume you did the Strickland analysis the way I suppose you're supposed to do it. And then we would just look at the facts and say, would they add up? But we do it with deference to that judgment. And I guess where I'm stuck is if I thought it was deficient performance not to do an investigation, it was then the question is, okay, now I've got this evidence before me. Would that have gone to a jury? And we have a counsel saying, I wouldn't have used it. Even if I might be inclined to think that you're right, that if it was a de novo question, that still would be prejudicial. Wouldn't it be reasonable for a jurist, if we were giving deference at that level, to say, well, it's at least a reasonable view to say that, no, it wouldn't have gone to the jury because it would have been a strategic choice at that point not to put it forward. So in other words, Richter would suggest we owe some deference to that judgment, even if wrong. So does Richter apply there? Because if it does, that seems to make your case at the prejudice level quite difficult on diminished capacity.
Richter, you mean, do you owe deference to the SJC on this question?
Yeah, when they haven't explained themselves.
And the answer is you don't, and they explain themselves in Judge Blank's footnote 1, combined
time.
Blank's opinion. May I answer, Judge Barrett?
Yes, please.
Thank you very much. It's critical to the case. What Justice Blank and the 3-judge opinion did was say, we are not visiting prejudice because the defendant has disqualified himself by his statement to Judge Walters and by his refusal to reach he has disqualified himself from relief without reaching.
What I'm asking you, though, that statement pertains to their analysis of the legal responsibility defense. It doesn't address diminished capacity.
So
under Richter, we have silence with respect to diminished capacity. So am I supposed to assume they would use that same reasoning into their unexpressed holding as to diminished capacity? That's what's odd about the case.
Yes, they used the same wrong reasoning to defeat the claim. So
how do I know that? How do I know that with respect to diminished capacity? That's my question.
You know it from footnote where the judge says there's no reasonable basis for thinking the outcome of the trial would have been different and the diluting effect of the defense. That's where I think.
Does that footnote address diminished capacity?
No,
it
says it would have been useless to offer this expert. I think that's right.
Thank you, Ms. Greenberg.
Thank you, court.
That concludes the arguments in this case. Attorney The next case today is Commonwealth School Incorporated versus Commonwealth Academy Holdings, LLC et al., appeal number 201112. Attorney Ray, please introduce yourself on the record.
May it please the court, my name is John Ray, and I represent the appellants in this action. Your Honor, I'd like to reserve 2 minutes of my time for rebuttal.
Yes, you may.
Thank you. This appeal arises from a 3-year adjudication of a settlement agreement in which the district court found in 2016 an enforceable settlement agreement between the parties. That on the one hand, appellants had agreed to change the name of their school, and in exchange, plaintiff had agreed to pay $25,000.
Mr. Ray, before you get too deeply into the merits, there's a substantial question in this case as to whether we have appellate jurisdiction. And I'd appreciate it if you'd early on address that and clarify that for us.
Sure, I will start at that issue, because that seems to be plaintiff's predominant defense here, the procedural issue of appellate jurisdiction, and whether the exception to the merger doctrine for an interlocutory order applies in this case. Normally, the exception precludes merger into the final order where a plaintiff has found his case dismissed for an unreasonable delay and failure to prosecute their case. As we addressed in the briefs on the motion to dismiss, and again in the briefs before the merits panel, this exception to the merger doctrine does not apply in a case where the defendants are accepting a dismissal for prejudice, not only of their counterclaims, but also of plaintiff's claims as a means of seeking immediate appellate review of a prior interlocutory order. The Supreme Court in U.S. versus Procter & Gamble, 356 U.S. 677, addressed a similar question with respect to voluntary dismissals and accepted that as a means of seeking appellate review. Further, the exception...
Does it make a difference in this case that the district court very pointedly invited not just the plaintiff, but either party to let the court know if they desired to have the case reopened and go forward?
I don't, because quite frankly, I would liken that to essentially a voluntary dismissal. It is asking the parties, would you like to proceed with your case? And so if, for example, the plaintiff or defendants, for example, had said, Your Honor, we'd like to voluntarily dismiss, the court said very pointedly, well, I'd like to dismiss this with prejudice, but you know, if you're not going to move this case forward, and took, instead of giving the voluntary dismissal, simply dismissed it for lack of prosecution. Usually you see that in a case where there's some unreasonable delay. The plaintiff has done something where it merits dismissing the case because plaintiff, or even defendants for that matter, if in this case, were not moving their case forward. Not in a case where they've elected specifically to dismiss their case, and in defendant's case in particular, dismiss it so that they could seek appellate review of an interlocutory order that would have otherwise ended the litigation. And that was the holding in Bethel versus McAllister Brothers out of the Sixth Circuit. That's 81 Fed 3rd 37, which was, Judge Cheol, are you jumping in there?
Well, go ahead and finish. I did have a question.
Okay. That was the holding in Bethel versus McAllister, that where a party is accepting a dismissal, a final order, and simply seeking to appeal an interlocutory order that would have brought the litigation to conclusion, the exception to the merger doctrine does not apply. A plaintiff in this case has not cited any case in which you have this circumstance where a party is actually seeking dismissal. And that's what the parties were doing, and that's what the court had poignantly asked. Are you essentially seeking to end this case? Which they were, because defendants wanted to go ahead and appeal. And the issue is, really, it puts defendants in a very awkward position. And we were in an awkward position where if we did not want plaintiffs' claims to go forward. In fact, we believe there was a settlement. And given the settlement, we simply wanted a determination and appellate review of whether there was a meeting of the minds, the legal decision that effectively ended this case.
I'm having some trouble figuring out what this case is about now, because you have a dismissal of the plaintiff's claims with prejudice. I would thought that's the number one thing you wanted at the outset of this case and would want it now, and yet you're the one appealing and asking to go back to the settlement. What's the difference? How are you better off? I don't understand what you're trying to get that you don't have.
Sure.
Is it the $25,000?
It's the $25,000.
And that's it?
That's it. This case, there was an agreement to change the name of the school. They did. They didn't just change the name in a sort of, ephemeral, we're going to change the name. They changed.
Let me just come back to that. I'm trying to understand this. These two schools have between them undoubtedly spent more than $25,000 on this appeal, and you're telling me the whole appeal is about the $25,000.
They haven't spent, combined, that may be true, but it's about enforcement of the settlement agreement and the terms of the agreement, and that the parties, and quite frankly, it's about whether an agreement can simply be avoided, whether in fact what was going on was plaintiff wanted the name changed. They agreed to pay a certain amount. It doesn't really matter the specific amount. Once the name was changed, then they refused to pay it, and the suggestion is that that's okay. This is not a school that has a lot of money. So this is a school that largely is providing scholarships and opportunities to inner city youth. Every dollar counts. $25,000 is a lot of money to this school. And in fact, if we're talking about the cost of the appeal, part of this has been done pro bono because this is an institution that serves a community that simply has been under-resourced, and that this is $25,000 that would substantially go into improving not only the school, but the lives of its students.
Now that it's clear the whole thing is about this $25,000 dispute, that does raise the Kekkonen issue, which is the other potential barrier to appellate jurisdiction, which is what is the source of our jurisdiction over that dispute? It seems to me that the only thing it could be is if the district court retained jurisdiction over it. And what's puzzling to me is in the typical case where I think we would want to apply Kekkonen to say that what's just a pure state law contract dispute nonetheless should be resolved in federal court would be if the federal district court had some desire to ensure that her enforcement power wasn't being undermined, and then we would take the appeal from that. But every indication here is the district court wanted to get as far away from this dispute as possible. So, and in fact, she says, I think at one point, well, if you tell me I have jurisdiction, I guess I have it. She never says my order clearly incorporates this and I retain it. So it seems to me that there's a fairly substantial question as to whether this is properly in federal court at all. If you guys want to have a state contract dispute and fight it out in state court, go ahead.
Right.
Why would we just say that there's no jurisdiction for that reason?
I think for the same reasons as we had discussed, that certainly the court, and I think had agreed at a certain point that to the extent the parties wanted to litigate an issue of breach of contract, that would be litigated in state court. And I think we would agree with that proposition. But here we are talking about the authority of the court when it has entered a settlement agreement, enforced that settlement agreement, and required full performance over the course of 3 years. That's so much so, in fact, that even at the final hearing, counsel for plaintiff stated on the record that he agreed. It looks like, and I'm quoting, it looks like they have complied with the court's order to change their name to Springfield Commonwealth Academy. That was the end, essentially, of this order. The only thing then was for the court to require the payment of the settle amount that plaintiffs had agreed to.
So are you essentially concerned with the district court's finding, if we can call it that there was no enforceable settlement agreement?
Yes.
That finding, if you can't prosecute this appeal, that finding would be binding upon, not only upon the parties, but really binding upon a state court.
And yes, there is the very serious potential and likelihood that res judicata would apply, and that this appeal is the only avenue for the parties to seek relief with respect to that issue.
Is that true if there is no jurisdiction to appeal it under Kekkonen?
If there is no jurisdiction even to appeal, then no, but I think there's certainly a question of.
Then we have to worry about it if we say under Kekkonen that there's no jurisdiction. That's just as good for you as a ruling on the merits. Other than you got to mitigate it, or it might be better depending on how we come out on the merits.
Well, I think that it doesn't. It actually puts us then at a disadvantage, that we've gone through 3 years of compliance and we're simply asking for the court to enforce its order. And in fact, for the court generally in this appeal.
All right, you're better off if it's enforced. But I'm saying the thing that you're worried about, in answer to Judge Selye, is you need us to resolve it. Otherwise, you face a binding judgment on you that you can't get review of. But that's not true. If the reason we don't review it is because we say there's no appellate jurisdiction, unless Massachusetts law would treat the district court's unreviewable judgment on that as something that gets res judicata effect, which I don't know that that's true.
And that's kind of the point. I don't think we know, but there's certainly a risk that's pretty substantial to the parties that a Massachusetts court may not or may defer to the judgment of the district court, which is equally as problematic for purposes of this case, where we're simply not given the opportunity to address issues because at the outset we're facing a question of whether there's res judicata or any type of preclusion, or simply whether there should be some deference given to any factual findings that were made in the proceeding. At this point, what we're appealing then is a determination that would have ended this matter. And that almost comes up in any case where you're appealing a determination that was reversed that would have ended the matter but didn't. And so there's a bit of open-endedness to whether then there's a final resolution here, or because there's not in this case. And the court clearly.
Last point on this, I guess if we thought there was a Kekkonen problem, wouldn't that require us to vacate the district court judgment as well? Because she would have left jurisdiction also.
Well, I would think that she certainly would have jurisdiction to enforce the settlement agreement, as she did.
Not if under Kekkonen, not if she hadn't retained jurisdiction over that question.
And if that's ultimately the finding, then that she had no jurisdiction to even entertain a settlement agreement, I think we would disagree respectfully with that proposition. That I think as to the question of the settlement agreement and whether the district court can both address the question of whether the parties had reached a settlement in terms of enforcing a dismissal in this case, which effectively had entered in the beginning, that would be sufficient for jurisdiction in this case. And like I said, the court may rule ultimately it didn't have those problems. That doesn't necessarily benefit the parties. I think it continues this litigation unnecessarily for an amount, as Judge Kayada pointed out. We'd just simply like to conclude. But more than that, I do believe in a case here where you have ultimately a settlement and that there is enforcement of that settlement, that it would lead to appellate jurisdiction on the question of the propriety of the judge's entertainment and findings with respect to the settlement of the parties. Otherwise, it really undermines the settlement process. It undermines the mediation. We go in with absolute uncertainty as to whether anything can be settled. It's uncertain as to whether any party can trust the district court if after 3 years of adjudication, well, simply the court may reverse a finding and then there's no jurisdiction for appellate review. There then is no jurisdiction to consider any relief from that determination. Simply, why would parties mediate in federal court if, in fact, there's this sort of potential that you enter into a settlement, it's put on the record, it's enforced fully, and at this point, the school certainly can change back and incur all the costs that it did, but it has no relief in getting to the finality that it agreed to. It sort of then entrenches parties as to whether they'd even want to mediate or try to settle cases in the federal courts to find a lack of jurisdiction over a case that originally the court had jurisdiction and over a case in which the parties had reached a settlement and the court found jurisdiction to entertain that settlement and in fact did for over 3 years.
Thank you, Mr. Ray.
Thank you.
At this time, Mr. Ray, please mute your device. And Attorney Oliverio, if you could unmute your device and introduce yourself on the record.
If it please the court, my name is Lawrence Oliverio and I represent the appellee. Your Honors, I think the briefing all speaks for itself and I don't want to repeat any of it. All I want to do is address a couple of points that Mr. Ray raised. First thing is the $25,000. You are 100% correct. That is all this appeal is about. It's not about paying $25,000 to Mr. Ray's client. It's about paying $25,000 to Mr. Ray. And I can give you
that's no real difference. He's their agent. He's spending time on behalf of them. Instead of them having to pay him, the money goes directly to them. I'm still trying to figure out how two intelligent lawyers would end up in the First Circuit arguing over $25,000.
Well, the reason we're here, Your Honor, is because, let me address, this goes to the point that Mr. Ray raised about mediation being undermined somehow. What happened at the mediation was Mr. Ray's client agreed at that mediation to change its name to one name and one name only, Springfield Commonwealth Academy, and to provide, our client's understanding was to provide our client with an assurance that that was going to happen. And let me tell you why. My client spent 9 months before this case was filed trying to get some kind of line of communication with Mr. Ray's client to get them.
Rather than looking backward here, there's a section in the transcript where you seem to acknowledge that that the other side has substantially performed the quote-unquote agreement reached to settle the case. Is that true?
No, that is not true.
How have they not substantially performed it?
Because they were using, at that time, and we didn't know it at the time of that hearing, but at the time of that hearing, they were using the exact terminology and phrases that they had been ordered not to use. In fact,
but how about today? What do they do? Do you have a bone to pick with them today?
Yes, we do. In fact, right now, today, as we sit here, the first page of their website, if you go to springfieldcommonwealth.org, on the front page, it says Commonwealth Academy, Springfield. That is precisely the term that they promised not to use and that the judge ordered them not to use.
So then why aren't you appealing? Because you've lost your claim. Your claim has been dismissed with prejudice. You're over and done with. You lost your trademark suit. So now how are you going to control anything they do?
No, well, that was true as of the last 4 years. There is an ongoing infringement, which my client will make a decision about whether or not to pursue, either in a separate trademark infringement suit or by settlement. Let me say this. This is important. My client believed before it filed suit, it believes today that this dispute can be resolved apart from litigation. As you all know, litigation is the absolute last resort for anybody and everybody. It's expensive, it's time consuming, it's bad, it's just bad karma for everybody. And that's what my client desperately wants to avoid. My client believes right now that they can talk directly to Mr. Ray's client and resolve this case without having to bother Judge Talwani. It's that simple.
Did the parties participate in our camp settlement conference?
No.
And were you asked to?
No, we were not. I personally pushed mediation. I tried to get the judge to order us to mediation. Mr. Ray's client initially resisted that. Eventually, they agreed to it after the judge indicated that she was going to order them to comply with her orders. So they got the feeling that they were losing, so they decided to go to mediation. And that's fine. I probably would have done the same thing.
Get back to Judge Kayada's question, please. I thought for virtually all civil litigation, our camp mediation program was mandatory.
No.
So,
no.
Well, let me ask a practical question.
Right.
We've got both counsel here. We have a camp conference. You would meet with a very experienced former retired judge who's a very good negotiator, and mediator, would it make sense for, after this argument, not today, but in a short period of time, for the two parties to get on the line with our mediator and see if they can resolve this thing? Because it doesn't sound like you've had 4 years of rather unusual litigation that's got to be very expensive and disconcerting for both parties.
You know, I apologize, Judge.
I'm just looking for, don't run down the other side, just
No.
would your side be interested in that?
I apologize. I have to go back and correct myself. We were contacted by, I can't remember, you're talking about the mediator that's associated with the First Circuit, that camp conference. Yes, we were contacted by him, and the process failed.
So in other words, you've had the mediation and it has not succeeded.
That is correct. The First Circuit level mediation,
Right.
yes.
Right. If we can switch the subject back to jurisdiction, right? I've read your argument in the brief as to why you think we don't have appellate jurisdiction. But do you have any comments about whether or not the district court had jurisdiction to whether or not the district court had jurisdiction to enter the order that it entered finding no settlement agreement?
4 minutes remaining.
I would say, I believe there's no question that the district court had jurisdiction. Let me say something else about the agreement. The district court was initially, at the first hearing that we had before the district court back in 2016, that was based on a motion we brought for an injunction. And that was after mediation had failed. The judge was leaning towards issuing an injunction, but she proposed as an alternative that the parties stipulate to the agreement that she created, basically, on the record. So that's really how that agreement came about. And since the parties agreed to what she was suggesting, I would say no question, but that she had jurisdiction to find there was no enforceable agreement.
Is that true of the $25,000 piece of the agreement?
I'm sorry?
Is that true of the $25,000 payment piece of the agreement? That come from the district court as well?
It came from the parties, and the district court incorporated it into her order, so to speak. That we agreed to pay them $25,000 on 3 conditions: that they provide proof that they were complying with the change of name, that they changed the name to one name.
I have a different question. Was the $25,000 payment piece of that agreement, what relationship did it have to the release? Is that just a separate agreement, or is the release part of the agreement bound up with the agreement to pay the $25,000? Do you understand what I'm asking?
Not really. I mean, there was an agreement in principle that arose out of the mediation, but that was just an agreement in principle. It was never finalized.
Okay, well, the fight here on appeal we just heard is about the $25,000 payment.
That's correct.
So there's a claim that there's a contractual agreement for that payment to be made in return for the compliance with the name change, correct?
I'm assuming, yes, that is the appellant's claim.
That piece of the agreement is, I know, set forth in a agreement that also has a release provision, right? Releasing the claim.
No, there is no release.
Okay, well, what was the agreement? The agreement was in part that the claims would be dropped if what? Only if both there was compliance and the payment was made? In other words, what is the relationship between the payment piece of the agreement and the dropping of the claim?
The relationship from our end, and as stated by the district court, was that The $25,000, which my client deposited into escrow, by the way, as a gesture of good faith, would be released by the court in increments when and if the defendant, appellant, were to produce receipts and invoices proving that it had spent money changing its name. And she would release money in the amount of the invoices. That was the agreement that we agreed to, we understood, and we were agreeable to that.
I understand that. What's the relationship between that and the piece of the agreement which was going to have claims dismissed?
There was never an agreement to have the claims dismissed.
Well, you mean they were going to change their name and you were going to still have your claim?
We would have at some point negotiated a settlement with them, and we would have agreed with the court to a voluntary dismissal.
Oh, that sounds rather strange. The court said there was an agreement that would resolve. The court was clearly talking about an agreement that resolved the whole case. They would change their name. You would pay some money.
Correct.
And that implies, I mean, nobody makes an agreement like that without an understanding that the case is being dismissed.
We would have dismissed the case if they had complied with the judge's order. That's the best I can tell you. There was never a written agreement to that effect.
Well, I didn't say there was a written agreement, but nobody agrees to change their name and not get a dismissal of the suit.
Well, there's no question but that my client wants nothing to do with litigation. We would have been glad to voluntarily dismiss this case. And I will tell you, the fact is, the reason we did not move to reopen this case is, again, because my client believes that there is a realistic possibility of settling this case if they can get an audience with a rational person connected with Mr. Ray's client.
Except that Mr. Ray has been telling us that the reason that you want out at this point is because you've already gotten most of what you wanted, and now you're just trying to avoid the $25,000.
Well,
and that question is not going to get resolved in this court.
That's correct.
So trading pejoratives doesn't advance the ball.
Well, Mr. Ray's client, right now, as you said before, all of the claims have been dismissed with prejudice. So all of our claims in the past, have been dismissed with prejudice. But that doesn't, under trademark law, that doesn't eliminate a cause of action in the future if Mr. Ray's client continues to infringe our client's mark.
Well, how does that, if they continue doing what they were doing right before the case was dismissed, I'm not so sure about that.
The case was dismissed for failure to prosecute old claims. Those were
the claims. Well,
that was an infringement that occurred.
We may see you another day with that case, or the SJC may see you. I think your time has expired. Let me see if either of my colleagues have any more questions.
Nada.
Thank you. I think Mr. Ray had some rebuttal time.
Thank you, Mr. Oliverio. If you could please mute your device. And Mr. Ray, if you could please reintroduce yourself to the record.
Yes, again, my name is John Ray, and I represent the appellants. And I think in this recent round, the court is getting a little bit of sense of what we've been dealing with. That this is why we want to get finality with this settlement agreement now. And the court asked, Judge Chiara asked, well, is there any record where Mr. Oliverio stated that there was substantial compliance? I quoted him where he said, it looks like they have complied with the court's order to change their name. That's in the record in the appendix at page 614, lines 8 through 12. You can see, as Mr. Oliverio later agreed, in fact, there was substantial mediation efforts by the camp, the First Circuit. There's no need to necessarily go back, but we tried our best to comply with whatever request they had to get this thing settled. We simply can't do it. No matter how much we agree, no matter how much we're willing to do, We're still fighting this issue. We'd like to get some closure. As to the issue of whether there was a written agreement, that's also simply false. The parties, after the mediation, engaged and sent back what they thought were the written portions of, in writing, in an actual formal settlement agreement.
Let me ask you about that agreement. You agreed to change, your client would change its name to Springfield Commonwealth Academy, SCA or both.
That's correct.
And did the parties agree on the extent to which you could, in print format or otherwise, relatively diminish the prominence of the Springfield word relative to the Commonwealth word?
No, we did not.
So how did you have a meeting? And that's the whole fight, right?
Sure.
So how did you have a meeting of the minds?
Sure. Well, we had a meeting of the minds insofar as the court had adjudicated all of these issues with respect to every objection and made determinations as to every single one. The issue with respect to meeting of the minds and whether we have to agree on inch sizes, font sizes, goes well beyond what's required for a meeting of the minds. We have to have a meeting of the minds on the material terms. The written exchanges between the parties can be found in the record at the appendix 264 through 66. The fact that there is a written agreement that the parties had exchanged is simply in the record.
So you're telling us that the size of Springfield in writing and its prominence relative to Commonwealth is not a material term of the contract?
When the disagreement is about an inch, yes, I think that makes it not material. But then on top of that point, we said, look, we're going to concede. At the final hearing, we said, look, we're just going to concede the issue because we didn't want to continue to litigate about inches. We said, we'll give it. If we have to say exactness, if we have to say whatever the court wants it to be, we're going to simply accept whatever they're suggesting was the agreement as the agreement. At that point, we've eliminated the issue of materiality. The suggestion that there were conditions, one, is rebutted again by the written agreements that the parties had exchanged, but two, it's rejected by the limitations on their agreement to pay, which was contained in a written agreement and an oral agreement. The written agreement was not signed, but the parties had exchanged all the material terms. They submitted affidavits to the court as to the material terms. They did not vary from the writing, and the court adopted the exchange that you would change the name, they would pay you $25,000. There were no limitations, and the court had repeatedly rejected, this can be found in the court's order at 429, Mr. Oliverio's newfound suggestion that, in fact, well, we only agreed to these things, these things, these things. It wasn't found in the written agreements they provided. It wasn't found in the material terms they submitted. It wasn't found in the court's order. What we're talking about at this point is 3 years of adjudication.
I think your time
really
is
should
up.
bring this to an end.
Just one final question, just so I understand the practical outcome of this. If we concluded there was appellate jurisdiction and we ruled your way on the agreement, you paid $25,000, what is the effect of our ratification or endorsement of the existence of the agreement on the future trademark infringement claim that your opponent suggested they presently have? What's your understanding of what the effect of this agreement would be on that future claim?
Right. The agreement was a comprehensive agreement, including to dismiss the claims. Of course, no one would agree to this. This was said on the record orally when there was the mediation. This was said in between the parties' exchange of documents, like I said, at 264 through 66. This was said in front of Judge Talwani, that this is a comprehensive agreement. You're exchanging this money, you're changing your name, the claims are dismissed, which is why when she entered the agreement, she dismissed the underlying trademark litigation. I think that if the court sends this back, that the difference was not material, we had conceded the difference, they're obligated to make the payment, that would bring an end to this entire case, and this would be over, which is what they're expressing they want, we're expressing we want. We've said repeatedly we're willing to do, and whatever you may find remotely somewhere on the internet, we're willing to change, which the school has substantially, to simply bring this to an end instead of the just endless years of plaintiffs' objections as to why they should pay the $25,000 they promised. At the end of the day, this is holding them accountable and holding the integrity of a settlement agreement to bring it into litigation rather than have this go on for another 10 years, really about a very small amount, and to preclude what seems to be now here a further threat of additional litigation on an underlying trademark action that the settlement also dismissed. Thank you, Your Honors.
We'll call the next case.
Yes, sir. That concludes the argument. The next case today is Cheol Wu versus Charles C. Spackman et al. Appeal number 201527. Attorney Stein, please introduce yourself to the record.
May it please the court, Daryl Stein for appellant Cheol Wu. May I please reserve 2 minutes for rebuttal, Your Honor?
Yes, you may.
This appeal presents a case with diverse parties and a monetary dispute of more than $13 million, precisely the sort of dispute contemplated by the federal diversity statute. Yet the district court...
Counsel, can we just stop right at that statement? Let me offer you a couple of propositions. All right. First, you will agree, will you not, that it is the pleader's burden, plaintiff's burden to show jurisdiction?
That is correct, Your Honor.
Yes. All right. And our case law makes it clear that jurisdiction must appear from the face of the complaint. I've looked at every piece of paper that you filed, that 14-page document, and there is no allegation in that 14-page document that concerns the citizenship of either party. Am I wrong?
That is correct, Your Honor. You're not wrong, Your Honor.
All right. I then say to myself, there are no facts pled that illustrate jurisdiction. There are none of the trappings of the usual civil action. There was no institution of a proceeding by summons and complaint. How can we say there is diversity jurisdiction? Allow you to make it up by allegations in memoranda or other filings?
Your Honor, this case was initiated according to the district court's mechanism for the registration of state court judgments.
No, the district court does, excuse me, the district court doesn't have a mechanism for the recordation of state court judgments. The district court operates under Section 1963, which, and I understand that there's a dispute about this, but which, read according to its tenor, applies only to federal court judgments. Now, I understand you have an argument that it should be extended to state court judgments, but we've got no express holding of our court or of the Supreme Court, or indeed of the District of Massachusetts, saying that it applies to state court judgments.
Your Honor is correct that there is no binding authority on this question, but the District of Massachusetts has, since 1996, accepted the registration of state court judgments.
Never in a contested case.
That is correct, Your Honor.
I've had a law clerk look at every instance you cited, never contested. So there's no law on this. You're asking us to make new law and hold that a statute that on its face seems on first read clearly to apply only to federal court judgments should be extended to apply to state court judgments.
Your Honor, I don't think that the court necessarily needs to read Section 1963 to extend to state court judgments in order to find jurisdiction here.
No, if we had pleadings that showed diversity or the existence of a federal question or the existence of a question under the bankruptcy code, some other source of federal jurisdiction, I'd agree with you.
In other
But
words, you could have filed.
excuse me, but the 14 pages that you filed don't contain anything like that.
I'll address your question, Judge Selya, and then I think Judge Cata, you might have had a question. Your Honor, the basis for the subject matter jurisdiction under the diversity statute can be found under the pleadings that were submitted in subsequent in the litigation. That's to say that show the citizenship of Mr. Spackman as a U.S. citizen and a Massachusetts resident, and Mr. Wu as a Korean national. The amount in question is clearly above $75,000. Now, because those conditions are satisfied, there are the circumstances here to show subject matter jurisdiction under the diversity statute.
Wait a second. Even if we could look at those documents, you say that the other filings show that Mr. Spackman is a U.S. citizen.
That's correct, Your Honor.
Yeah. Is that alone sufficient to show diversity? I thought
Your Honor.
I thought the obligation of the statute was to show that he was a citizen of a particular state.
That's correct, Your Honor. And there's also evidence in the record showing that Mr. Spackman maintains a residence in the Commonwealth of Massachusetts.
That's right.
Including
and is residency the same thing as citizenship?
Not necessarily, Your Honor.
No, we've said the two are different concepts. The Supreme Court has said, but we've also said.
Yes, Your Honor, but based on the record that we've submitted, we believe that he is a citizen of Massachusetts. And on that basis, the diversity statute has been satisfied. So I think with that, I think.
For what action, for what claim?
For the debt that is owed under the judgment. There's a substantive right under Massachusetts state law for the enforcement of judgments. There are two statutes that provide for it.
But have you brought that action?
We have not commenced.
I thought all you've done was try to register the judgment. So how is that civil action that diversity statutes contemplate?
So I think there are two questions there, Your Honor. The first is how we commence the action, and then how that action that we've commenced satisfies the diversity statute. So the way that we commence.
No.
Okay.
You have to have a source of subject matter jurisdiction to register. One possibility would be 1963. So, but we're going to put that aside. Another possibility might have been 1738. You don't raise that on appeal. So what gives the district court the authority to accept the registration to begin with? The only thing I can see you've identified is diversity jurisdiction. But to accept the judgment to register, diversity jurisdiction statute requires it to be a civil action. And I don't understand how the acceptance of registration itself is a civil action. So I don't see how the diversity jurisdiction can do what you want it to do.
Your Honor, I think that the term civil action, as it's used in the diversity statute, it's not something that's been addressed in many cases, but I think those that have addressed it, and we've cited these in our briefing, refer to it in contradistinction to those actions that are criminal in nature. This is a monetary dispute over the enforcement of a debt. And the reality is that the U.S. Congress in Section 1963 and the state legislatures under the Uniform Acts that have been adopted.
Okay, so if we accepted that there's subject matter jurisdiction, doesn't the district court independently need some source of authority to accept the state court judgment? I mean, it can't just do what it wants. It's got to have statutory authority to do things. So what is the source of the authority to accept it?
Your Honor, I think the source of authority is the Massachusetts state law sitting in diversity that allows for the enforcement of foreign state judgments.
Yeah, but there was no Massachusetts state law allowing for the registration of the judgment. You want to register a judgment. That's what you first need the district court to do. What is its statutory authority to do that?
The statutory authority we think comes from the fact that there's diversity and the application of state law. Secondarily, the court can look to Section 1963 and the federal procedure.
What's state law? There's no state law authority to register, is there? At the time?
Your Honor, there are two statutes at issue. The first one is, I'm just pulling up the citations here for your reference, is 218.
That's time.
Well, was there a state law provision that allowed the registration of this judgment at the time you tried to register it in district court?
There was a different statute, 235-4A, that called for the execution of actions on judgments.
That's not what I asked. Was there a state law authority to register a judgment in state court at the time you tried to register this state court judgment in federal court?
There wasn't, Your Honor, although the question about jurisdiction...
That's a pretty unusual thing, because since you don't have the very act you're asking this court to do, you couldn't do in state court. So what could the federal court, what is the source of the federal court's authority to accept the registration if it's not 1963? It can't be the diversity statute. That's not a source of authority to do the thing. That just gives it jurisdiction to do those things it has authority to do. So what is the source of authority to accept the registration of the judgment?
I think that's a helpful distinction, Your Honor, because I think the question is then a matter of procedure and whether we follow the proper procedure for enforcing the judgment. But if the court has the jurisdiction between the parties based on the amount in controversy, the citizenship, and the fact that this is a civil dispute, then the question of procedure is one that can be addressed separately. But the court dismissed for lack of subject matter jurisdiction. But here,
but if that's fine, but we can affirm on an independent ground. So just humor me. If we got past the diversity jurisdiction issue, what would be the source of authority to accept the registration of the judgment in federal district court if it's not Section 1963?
Your Honor, if the court reversed the subject matter jurisdiction finding but found that the procedure was improper, the question would then be, what is the proper procedure for proceeding with this action? And we're here on the on what arose from a motion to quash a subpoena. And if the court were to find subject matter jurisdiction, but find that a different procedure needed to be followed, that subpoena could then still be enforced. It could
Only
be
if there was some other procedure. That's what I'm asking. What is the source of authority to register the judgment, which is the predicate for the subpoena?
The substantive right to enforce the judgment, we think, comes from the Massachusetts state law. We think that and in addition, I think that Section 1963, and this is the secondary argument that G.E. Betts made, can be read to include the statute, can be read to include the state courts. We don't think the court needs to go there, though, because the court's subject matter jurisdiction comes from the diversity of citizenship and Section 1332A2.
Thank you, counsel.
Thank you, Your Honor.
Attorney Stein, you can mute, and then Attorney Brooks, if you could unmute and introduce yourself on the record.
Yes, may it please the court, Doug Brooks for appellee Sohee Kim. Plaintiff in this case took a state court judgment that he obtained in New York and purported to register it in federal court in the District of Massachusetts pursuant to Section 1963. Section 1963 is the only mechanism that allows a party to register a judgment from another court in federal district court. And by its plain terms, as the district court correctly held, Section 1963 only permits a party to register a judgment from another federal court, not a state court. This conclusion is supported by the case law. There is not a single case that is held that Section 1963 allows a party to do what Mr. Wu sought to do here, register a state court judgment in federal court. And although the First Circuit has not squarely addressed the issue, there's no dearth of case law on the issue. We cited 16 cases from various circuits, the 2nd, the 6th, the 9th, and the 10th, and a number of district courts, directly holding that 1963 does not allow for the registration of state court judgments in federal court. The only court not to completely align with those decisions was the 7th Circuit in G.E. Betts, which held that the language 1963 was ambiguous in this regard. So GE Betts did not reach the issue of whether a plaintiff could register a state court judgment in federal court under 1963, but decided that because of what it perceived to be ambiguity in the statute, 1963 did not necessarily prevent a registration action outside of the statute under very unique circumstances, which are not present here, specifically that really wasn't just a registration action because there was a new party to that action. And so really the issue on 1963, I would submit, is clear. In sum, Mr. Wu cannot use 1963 to register his New York State Court judgment. So his fallback position, which we noted he did not raise until he filed a motion for reconsideration, is that irrespective of Section 1963, he can register the judgment under the diversity of citizenship statute. So as a threshold fundamental matter, and I believe your honors raised this, that's not what happened here. Mr. Wu did not invoke or plead the district court's diversity jurisdiction when he registered. He simply registered a state court judgment without any reference to the alleged diversity of the parties or otherwise state the basis for his subject matter jurisdiction. This is not surprising because the procedure when one registers a judgment under 1963 is simply the ministerial act of filing a copy of the judgment with the clerk. The judgment creditor doesn't make an allegation of jurisdiction because it's not relevant in a registration action. And this is shown in the Fidelity versus Friedman decision that we cite, 2019 decision, where it stated that the issue of jurisdiction, and there was personal jurisdiction, is irrelevant for 1963 purposes. So Mr. Wu next argues that he can register the state court judgment under the diversity statute because 1963 contains language that the registration procedure is in addition to other procedures provided for the enforcement of judgments. But the problem with that argument is that the diversity of citizen statute is not a procedure for enforcing judgments. It's a jurisdictional statute. And again, outside of Section 1963, Mr. Wu is unable to point to any procedures that allow for the registration of state court judgments in federal court. And if there's nothing else, Your Honors.
Just had a technical question. The district court dismissed for lack of jurisdiction.
Yes.
It's possible that's correct because we could read 1332 civil action in a way that would suggest this is not a civil action because it's just a request to register, assuming Section 1963 is not the source of authority. If we do that, that creates some tension potentially with the Seventh Circuit understanding of how to read the diversity statute. The alternative argument that you're suggesting is that there is no source of authority, even if there were diversity jurisdiction, for the district court to register the judgment. It's almost like akin to no cause of action as opposed to no jurisdiction. If we did that, that's not really a jurisdictional ruling. That's just a dismissal on the merits. There's just no authority to do this thing, even if we assume there was a diverse jurisdiction. And I guess you have to do is between those two things, because your second argument does sound more merit-like rather than civil.
Yeah, although I think if I'm understanding you correctly, Judge Barron, I think that if it's dismissed because if it's dismissed because there's no cause of action, then there's still no subject matter jurisdiction, simply because that
well, that's not. In other words, if I bring a state law cause of action in federal court with diverse parties, I clearly satisfy diversity jurisdiction, but we sometimes dismiss because the cause of action you claim turned out to be wrong. It didn't really exist under state law. That's a merits ruling, not a diversity point, because the court had jurisdiction to entertain the question. Here, there's a prior question whether we even had jurisdiction to entertain it, because maybe it's not a civil action given the nature of the thing they're trying to do, which is just register a judgment. But there's a second point, which is even if they are trying to register a judgment and we do have diversity jurisdiction over such a thing, a la the Seventh Circuit's ruling about how to read the diversity statute in Betts, nonetheless, there's just nothing that's been identified that would give any authority to this district court to register this state court judgment. That's just the merits ruling.
I think that's right, Your Honor. As I see it, there is no subject matter jurisdiction for all the reasons we laid out. But even if the
4
court
minutes remaining.
even if the court found that there was subject matter jurisdiction, it necessarily should be dismissed on the merits as well.
Are there any other questions from Mr. Brooks?
No.
Okay. Thank you, Your Honors.
Thank you.
Thank you, Mr. Brooks. We have a 2-minute rebuttal from Mr. Stein. Mr. Brooks, you can mute your device. Mr. Stein, please reintroduce yourself to the record.
Thank you, Your Honors. Daryl Stein on behalf of Mr. Wu. I'd like to begin briefly with GE Betts because I think that case is an important one because it's the only case that has squarely addressed the question that's before the court here, which is whether there is federal subject matter jurisdiction where an action has been commenced by registration and there's diversity of the parties. And that's precisely the situation we have here. Now, the question we've been turning to is what is the source of authority, which I think is both a question of substantive right and of procedure. And I think on both of those points, I think the Massachusetts statutes are essential. There's one that provides for the execution of judgments, that's MGL 235, section 14, which requires the filing of a transcript, which is precisely what was done by the registration in the district court. The other is MGL 218, section 4A, which is the Massachusetts adoption of the Uniform Enforcement of Foreign Judgments Act. Your Honors, this is a situation where a judgment debtor...
Were both of those in effect the day you filed this registration?
The first was.
And the second wasn't, right? So
the second became effective because, Your Honor, if this is a question about what procedure needs to be followed in order to pursue this, the subject matter jurisdiction we believe is satisfied by the diversity of citizenship of the parties. What we're talking about is the procedure. So if this is reversed for, if this court were to reverse and find that there was subject matter jurisdiction and require that it be repleted or refiled, then the court could apply the district court could apply the statute that's in effect now. It could require that it be commenced as an independent action, but the fact would remain that Ms. Kim has been validly served with a subpoena pursuant to Rule 45 and would be required to answer.
It's quite a stretch to say, yes, you could use now an cause of action that didn't exist prior, but even if we said that, how does that then spring backward in time and make the subpoena valid? You'd have to serve a subpoena again, wouldn't you?
Your Honor, we think that Ms. Kim was served while in the Commonwealth of Massachusetts.
That's time.
If I can finish, Your Honor.
You could finish.
Your Honor, the action was commenced in according to the procedure that's been followed for years in the District of Massachusetts. Now, understanding that the court might have some reservations about that procedure, those reservations about procedure are different than the reservations that the district court based its judgment on, which was the lack of subject matter jurisdiction. And if there is subject matter jurisdiction, that case was before the court on the basis of diversity, then the question of the procedure, the question of the enforcement of the subpoena are questions that can be addressed by the district court on remand.
Thank you, Mr. Stein.
Thank you, Your Honors.
That concludes the arguments for today. This session of the Honorable United States Court of Appeals is now recessed until the next session of the court. God save the United States of America and this honorable court. Counsel,